Yeah, please, your lordships.
Yes.
Item 51, 52, and 53. This all three items are in the bottom of the hearing list. And in all the three items, on previous occasions, there were orders to expressing the urgency to be taken up early. And then I have been allowed to make a mention for upgradation of the items.
I see.
Item 51 and 52 is with regard to the selection process of the excise constables, where more than 10,000 candidates have appeared, and this honorable court has allowed to proceed with the selection process. But then the result shall not be declared without the permission of this honorable court.
Okay.
And accordingly, we are on completion of the selection process, we file an application, IA. But then instead of considering the IA, let us go for a final hearing of the entire case. So that urgency is there because the fate of more than 10,000 candidates are waiting. So I would like to pray before the honorable court to upgrade this item for as the first hearing item after the part one matters.
51, 52.
And so
53.
53 is concerned. This is pertaining to the promotion to the post of secretary in the Nagaland Legislative Assembly. And then here also the urgency has been expressed. However, once the item 51 and 52 is taken up, then not very likely to reach the item 53. So may I pray that this 53 may be taken up next week, that is on 25th, since we have only 1 day division bench. Of course, that can be.
Who's appearing for the other side? Says that.
Yes,
You
we are
agree?
appearing.
You agree?
Yes,
I am
for our respondent number one.
You also agree?
Yes.
Please, item number
Item 53.
53, right? As agreed to by the.
Let it be as first item in the hearing this next week because the order is there. Pray for upgradation today. But
Okay.
it can't be taken up.
Okay, as agreed to by the parties, list this matter on, what is the date?
25th, I believe.
24th of June 2026 for hearing as the first item in the hearing column.
Much of it.
Then in respect of the,
51 and 52,
who's appearing for the other side?
Mr. Tongpo.
Yes, you are there?
Yes.
You agree for the upgradation?
Yes, Lordship.
Okay. How many hearing matters are there?
Before entering the honorable court, we had a formal chat with my learned friend Ezo. He has a hearing matter item 21. He said there is urgency. So I inquired, what is the urgency? It is imprisonment for life. Then I think if it is for life, then there may not be much urgency. Unless he has information that next week or after 2 weeks, my life will end.
So he's a healthy person. Okay. Good. Mr. Ezo is here.
So
he's
I
here.
have requested him to accommodate us for a day.
But you have circulated one adjournment slip on item 17.
I have two hearing today, criminal hearing, 17 and 21. I'm prepared for 21
I see.
because I cannot do two criminal in a day.
I see.
And actually in 21, I'm a friend of the court. I'm a security.
Okay.
Anyway, Lordship, since my senior has prayed for upgrades, then I have understood that.
Upgradation. There was one thing occurring in our mind. We can have two choices. One is upgradation, first item in a hearing, or we can have a two.
Lordship, either way.
Two will be better.
Two.
So in the meantime, if there are short matters, we can just, take care of those matters if possible.
But you have to, will you, sir, complete it in the second half? 1 half will be enough to complete? Because part third will be a problem because we have 2 more days, but
I believe even if it is taken up at 2,
it will be
within 1 hour, hopefully
It's a short.
we'll be able to finish.
Okay.
I can wait for that.
Okay, we'll have it at 2. 2 o'clock. Item 51, 52 at 2, okay?
Obliged, Lordship. And item 16 and 39, these 2 matters may be taken up after the vacation.
16.
And 39. Both are in the hearing list.
16 and 39.
16 and 39.
16 and 39.
39. What is 39?
Matter of-
Both are criminal matters, lordships.
16 is quite old, no?
They are related.
Not custody, right? Not in custody, right?
16 and 39 are related to each other
No,
or different?
Different.
different cases.
16, I think the paper book has been circulated.
Yes. It
Okay.
is an appeal against acquittal, lordship.
Appeal against executed.
Okay, 16, when do you want it?
Up to the vacation,
Okay,
lordship. Summer
item
vacation.
16, you write, as paid for by Mr. C.T. Jamil and senior counsel for the appellant and not opposed to by the other side, list the matter again after the ensuing summer vacation. Similarly, in item number 39.
39.
Okay,
39, 39.
39. Same order.
May I please, Lordship?
Yes.
Lordship, I beg to mention item 10, that is an order item. On the last occasion, there was no representation from the side of the respondent.
Uh-huh.
Now, all the respondents are being represented, Your
Mhm.
Lordship.
Mhm.
So if this matter will be listed for admission hearing after vacation, Your Lordship.
Okay. Who's respondent now? Topo?
I taken this consent.
Yes, also for respondents 73, 74, and 75.
Okay. So all are represented now?
Yes, all are
Please
represented.
write, Mr. T.B. Jamil, learned counsel for the appellant submits that all the respondents are now represented by their respective counsels. And he prays that the matter may be listed in the admission column after the ensuing summer vacation. Stop. In view of above, registry to list the matter for admission.
On 22nd, Your Lordship, 22nd, Wednesday, 22nd,
On 22nd of July, 2026, as paid for.
highly obliged.
Right. Yes.
I beg to mention item number 3 and 4. Here, I'm yet to complete the counter affidavit.
3 and 4.
3 and 4.
There's an observation from the court.
Lordship.
What is to do? How do you overcome that?
Lordship, here, AG is going to appear, but we need some more time because it's very sensitive and there is a huge public demand. So the affidavit is yet to complete, so this may be listed after summer.
Are you preparing it or it's not yet received?
No,
instructions?
I'm preparing, not
You're preparing.
completed. And I have to send it back to the AG. For
I see.
settlement.
Yes,
Yes,
Mr. Jamir and Mr.
I mean,
Tagamasa, you both have your own
See,
PLs,
it's-
separate PLs.
There is urgency in the case,
Mm.
but then if that is the situation, but ensure that he will not pray for further times.
The same submission is continuing for the
Yes.
last few months.
Yes.
Let us ensure that by next day, things are ready.
When can you file it? Give me a
Yes.
date.
Before 22nd, we'll be able to find.
22nd of July.
Lordship,
So we'll list on 22nd then.
Lordship.
22nd?
Lordship.
Mr.
I am so.
Im Song, learned additional advocate general Nagaland submits that he is led by the advocate general in the matter. And that counter affidavit on behalf of the state is under preparation. Stop. He therefore prays for at least 3 weeks' time to finalize the counter affidavit and file the same. Stop. Mr. Takamasa and his senior counsel are praying for the petitioner in PIL 2 of 2026 and Mr. C.T. Jamil and his senior counsel are praying for the petitioner in PIL number 4 of 2025. Submit that if the learned additional AG is going to file the counter affidavit within the next 3 weeks, they have no objection.
But no further adjournment, Lordship.
They also submit that no further adjournment should be granted. Next para. Considering the above submissions, matter stands adjourned to be listed again on 22/7/2026 with an understanding that the state respondents will positively file by their counter affidavit on or before the next date. Right.
Lordship, in item number 5 also, there is an instruction of the number court to appear AG. But Lordship, I may be allowed to clarify that, and if possible, I'll be appear on behalf of the state. So the matter may be listed after vacation.
Mr. Takamasa?
Lordship.
Okay,
A date may be given, Lordship.
okay. Mr. Imti Song, learned counsel for the state respondent, submits that although notice was issued to the learned advocate general, he has instructions to appear on behalf of the state in the matter. And he prays that the matter be listed after the ensuing summer vacation. Stop. Mr. Takamasa and his senior counsel appearing for the appellant has no objection to the prayer. In view of above, list the matter after the ensuing summer vacation
Lordship, may kindly give us a date?
on so and so. Any particular date? You want to be okay?
17 to 15. 17. 15 is Wednesday.
15 is Wednesday, 17 is Friday.
That is right.
15? On 15 July 2026, okay? All right.
May I please, my lords?
Yes.
I'm praying for listing of a writ appeal next week. It was last listed in the month of March.
Okay, okay. A listing for what? Admission orders, hearing?
For passing necessary orders.
What is the stage?
Lordship, it has not been admitted.
Okay,
New matter, new matter,
it's a fresh matter.
fresh matter.
No, your lordship, if your lordship remember, we have filed in contempt also. It has come.
Okay, okay. Yes,
Obliged, lordship.
May I please, Your Lordship. I should beg to mention, hearing item number 46 and 47, my lord.
46,
My lord, yeah, for the private respondent number 1,
46,
46 and 47, my lord. My lord, if these matters can come up after the vacation, my lord, this is a consensus prayer, my lord.
It will not read, so it's okay.
Okay. As paid for by Miss
Miss Lucino, my lord.
Lucino,
Yes, my lord.
learned counsel for the
Respondent number 1. my lord.
respondent number 1, and opposed to by the other side. Matter stands adjourned to be listed again after the ensuing summer vacation. So, all right.
This one also.
Obliged.
May I please, my lords? My lords, subject mention item 38. Lordship, my senior, Mr. Limao Bang, is out of station, so the matter came up after the summer vacation, Lordship. Item 38.
Hmm?
Item 38.
You want a date or?
No, Lordship. No, Lordship.
Okay, Mr.
No specific
Fonseca Forte, learned counsel for the appellant, suppose that he is led by Mr. Lima Wapang, who is currently out of station. He therefore submits that matter may be adjourned and be listed again after the ensuing summer vacation. PP, Nagaland,
Lordship.
learned counsel for the learned public prosecutor, Nagaland, does not have any objection to the prayer in review of above. List again after the ensuing summer vacation.
Lordship, similar prayer for item 41. Lordship, 41, I'm led by Mr. Taliao, Lordship. Lordship, he's not keeping very well. So, Lordship, if the matter came up after the summer vacation, Lordship.
Yes, GA and CGC,
Yes, Lordship.
no objection?
Yes.
Okay. Mr. Fonseca Forte, learned counsel for the appellant, submits that he is led by Mr. Taliao in the matter. And since Mr. Taliao is indisposed, he prays that the matter may be adjourned and be listed again after the ensuing summer vacation.
Lordship.
Prayers allowed. Please the matter again after the ensuing summer vacation as prayed for.
Hello, bless my lords.
With your permission, Lordship, would like to mention item 54, today's list, Lordship, supplementary list. Lordship would like to file, place on record the affidavit. I'll be filing the affidavit on next week, Lordship. Let the matter be taken up on next Wednesday.
You are for the,
For respondent number 5, insurance company, Lordship.
okay. What kind of affidavit you are going to file?
Lordship, in terms of order to the 25, 26, Lordship, the respondent number 4 has filed one, brought on record certain claims, Lordship, certain figures. So we have to file the explanation to that, Lordship.
Okay, your good name?
A. Kakoti for respondent number 5.
Okay. Anyone appearing for the petitioner?
Lordship, I'm
Any
for the
objection?
petition. No objection, Your Lordship.
Mr. A. Kakoti, learned counsel appearing for the respondent number 5, submits that he may be granted a week's time to file an affidavit in terms of the order dated 25/2026. Stop the said prayers not opposed to by the learned counsel for the petitioner. In view of above, list the matter again after a week
Your Lordship.
on so and so.
Please, your Lordship. Your Lordship, the respondent number 6 has also filed an affidavit this morning. The same will be placed on record, my lord.
Filed on, list again on, what is the date? 24, isn't it? On 24th of July, 2020, 24th of June. June. Mr. Joshua Seki, learned counsel appearing for respondent number 6, submits that the respondent number 6 has filed an affidavit this morning. Registry to verify and connect the same to the report. Lordship, correct? Obliged, Lordship.
May please, Lordships. Your Lordships, I beg to mention item number 17, my lord.
70,
Item number 17.
17.
Yes, my lord.
Ah,
My lord, here we have filed adjournment application also.
Okay, when
And I
did it?
paid it after 2 weeks, my lord.
On the request of Mr.
B. Soto. On behalf of Takakichi.
Not in custody, right? Not in custody. Appellant is in custody.
Appellant. Item 17.
17.
Yes, 17.
Appellant is not in custody, right?
Not in custody, my lord.
In view of the adjournment slip circulated by the counsel for the appellant and not opposed to by the other side, matter stands adjourned for 2 weeks. Lest again after the ensuing summer vacation.
Much.
I please, Lordship. Lordship, I beg to mention hearing item 22. Lordship, I'm appearing on behalf of Hakim Chapo. Lordship, can the matter be listed after vacation as my seniors have some personal difficulties?
Lordship, I have no objection.
Pakin Richabo is for what?
For
Sole respondent.
for the respondent, my lord. There is only one respondent, the accused. Here we are challenging the order by which bail was granted. To the
Okay,
accused.
when do you want it? After vacation?
Yes, Lordship.
No objection.
No objection.
Okay. On a request made on behalf of Mr. Pakin Richabo, learned counsel for the sole respondent and not opposed to by Mr. Sentianger, learned special counsel, learned special PP and IA. Matter stands adjourned to be listed again after the ensuing summer vacation.
Simply obliged, my lords. Lordships, I would like to mention one item, Lordship, to be listed next Wednesday. Here, when the interim order was passed, there is a clerical error. Instead of writing 140, WPC 141, WPC 140 has been entered, which is why it is creating some confusion in the department. So if it can kindly be listed next Wednesday, my lord. The next posting is only after the summer vacation, which is why.
All right.
Deeply obliged, my lord.
Ms. Ayemi, anything?
Your Lordship, I beg to mention item number 7 on behalf of Miss Livika. She's yet to receive instructions here, so if this matter cannot come up after the vacation.
Writ appeal.
Yes, Your Lordship.
What instructions required?
Your Lordship, I'm not handling this matter. She just informed me.
I know, but the thing is that appeal means what? The pleadings are already there, petition, counter affidavit, what more instructions do you?
Regarding argument, I guess.
Okay, Ms. A. Ayemi, learned counsel, submits that Ms. Livika, learned government advocate, is appearing for the state respondents in the matter. And since she's awaiting some instructions in the matter, she prays adjournment on her behalf. Any objection? Learned counsel for the petitioner, appellants. There has no objection to the prayer. In view of above, matter stands adjourned. To be listed again, when?
After the vacation, Your Lordship.
After the ensuing summer vacation. All right.
Your Lordship, item number 14 also on behalf of my colleague Inaholi, Your Lordship. She's indisposed, so if this matter can come up after the vacation.
Item 14.
Yes, Your Lordship, 1-4.
Who is appearing for the appellant?
Lordship, I'm appearing for appellant.
Any objection?
Lordship, if the matter can be taken up next week, because this pertains to the suspension, Lordship.
Your Lordship, she's indisposed, so she has.
Who's
Inaholi, Your Lordship.
Inaholi.
Yes, Your Lordship.
But by next week, she should be better, hopefully.
Let's hope, Your Lordship, then.
Your writ petition was dismissed,
Lordship,
prolonged suspension,
Lordship,
but you have been given charge memorandum already.
Lordship.
That is why court said that there's no question of that judgment. What is that? Without review of the suspension will not apply. Anyway, Ms. Inali, learned government advocate appearing for the state respondents, is said to be in this post. And Ms. A. Aimi, learned government advocate, also raised adjournment on her behalf. However, the learned counsel for the appellant submits that there is urgency in the matter and prays that the matter be listed after a week. In view of above, list this matter on 24th June. We'll make an attempt. If any problem, you can always inform the court. Okay.
Much
Nice.
obliged.
Yeah, please, Your Lordship. Lordship, I beg to mention item 15 on behalf of H. Mukam, counsel for respondent number 4. Lordship, he is on medical leave and is out of station. I'm informed that he will be filing objection to the IA for condemnations of delay filed by the petitioner. So if the matter could be listed after the vacation.
Respondent number 4.
Yes,
Who's appearing?
H. Mukam. His name is not reflected in the course list. However, he had prayed for his name to be reflected in the course
Has he
list.
filed his power?
Lordship?
Did he file the Vakalatnama?
Yes, Lordship.
Just give me the file. Item 15. Somehow I found that it's one or four not served. Obviously. Heat post. Return awaited. No, there is no Vakalatnama.
Lordship, he has already appeared in previous date.
When?
25-26.
What is his name?
H. Mukam.
But he did not file his Vakalatnama. Is any Vakalatnama in the file? Why is he absent today?
Lordship, he is on medical leave. His name is reflected in
Your good name?
Pangom W. Keman. Lordship, I'm not in this matter.
I know. Give your name again.
Pangom, P-A-N-G-O-M.
It is right there. Mr. So-and-so, learned counsel, appearing on behalf of Mr. H. Mukam, learned counsel appearing for respondent number 4, submits that as Mr. Mukam is unwell, he is unable to appear before the court today. Stop. He therefore prays for 2 weeks' time.
If the matter could be listed after the vacation.
He therefore prays that the matter be listed again after the ensuing summer vacation, and in the meantime, Mr. Mukam will be filing the objection to the IA. Stop. Para. It is noticed that although Mr. H. Mukam had appeared on the earlier occasion also, but he has not filed his power as yet. Learned counsel shall file this power as well as the objection by the next date. List again after the summer vacation.
Obliged, Your Worship. Lordship, if I may be allowed to mention item number 6, Lord.
6.
Lordship, if this matter may be taken up next week, Lordship.
Shivapom,
Yes, my lord.
this is your appeal.
Yes, my lord.
Your name is not shown. Mr. Moajamil.
Lordship, I'm here to file my Vakalatnama.
Mr. Moajamil, learned counsel, submits that he will be appearing on behalf of the sole respondent and prays that matter be listed again after a week. Mr. Hithibapom, learned government advocate, appearing for the appellants, has no objection. List again on so and so. Give the date next week, 24th June. Learned counsel, Mr. Moajamil shall file his power by the next date.
Lordship.
Okay.
Lordship. Obliged, Lordship. Much obliged.
May it please Lordship, Lordship, I beg to mention hearing item number 49.
A long list today, isn't it?
49.
49.
Yes. Lordship, here, Advocate General is leading in this case. So I pray that the matter may be fixed on 19th of August. Because right after summer break, Lordship, he has so many other matter fixed in the Supreme Court.
49.
Yes.
State is a party.
Yes.
Response number.
May I please your lordship? My lord, state is a pro forma respondents here. Only a pro forma. My lord, the matter relates to selection of process of special recruitment drive for nurses who had served during COVID. Now, single bench has passed a judgment in our favor, then this is a read appeal by. So, my lord, in view of pendency of this, the selection process, special recruitment process could not be held for doctors already result declared. So there is an urgency in the matter. My lord, in the connected matters in the doctor's case, the learned advocate general was appearing. But since the additional AG is appearing and the government is only a pro forma respondents here, may I pray that let that additional AG take over the matter and we dispose the matter at the earliest.
Lordship, we are not pro forma respondent. We are the main party here. So
But who's the appellant?
And what happens?
I mean, who are they? You are the private respondents in the writ petition.
Yes.
No, you were not, you were not a party to the case.
Third party appeal.
You were not,
Third party writ appeal.
yes.
What is your interest?
Our Lordship, here in this matter, in the writ petitions, without the affidavit of the government, the matter was disposed of. And the petitioner, they never served during the COVID period, Lordship. So the situation is different. So in this case, last time we saw time to file our affidavit and the court had allowed. We had prepared.
You have filed?
No, Lordship, because there is some confusion with some annex here. So 1 week time, within 1 week time, we will file our affidavit.
Take a short date then.
Lordship,
If so required, will
next week
you
we
renew
will-
your prayer?
Yes, Lordship, next week we will be filing our affidavit. And right after vacation, the learned AG, he has other fixed matter in Supreme Court. So Lordship, as a kindly consider him and fix on 19th of August. We make sure that we take up the matter.
There are 3 or 4 additional AGs.
Yes.
You
So,
at least have the AG sometimes. Why are you always?
It isn't a big issue, Lordship. It is not a big issue.
This
So,
one,
so my respectful submission, let one of the direction will be issued, that let one of the additional AG appear in the case. Because, Lordship, the delay in the process.
Lordship, this
And
case will have
in
a
the-
larger
Because
ramification.
the question is, in similarly situated matters for the doctors, division bench allowed in their special recruitment tribe conducted and they are already appointed.
We'll have a date just after the vacation. And in the meantime, you decide amongst yourself whether AG will ultimately appear or somebody else can come and appear.
Lordship, my prayer is that in this case, this is going to have a larger ramification if the writ.
We will
appeal
record
is
your
dismissed.
prayer, but we will post it again after the vacation.
Lordship.
Then you come up and renew your prayer. You may have there may be some developments also.
Oh,
Yes.
you may be able to.
Please write Ms. V. Shokre, Learned Additional Advocate General, submits that the Learned Advocate General will be appearing for the state in the present case, and since he has some personal difficulties to appear in the matter today, and also in the near future, in the month of July, she prays that the matter be listed sometime in the month of August 2026. Mr. Takamasa Lanet, Senior Counsel, appearing for the appeal, and on the other,
Private respondent, Lordship.
appearing for the
Private respondent.
private respondents, on the other hand, submits that the state respondents are only a pro forma respondents, and that if the Learned Advocate General is unable to appear, the other Learned Additional Advocate Generals may conduct the matter. Stop. Ms. V. Shukre, Learned Additional AG, however, submits that the state is a necessary party and not just a pro forma respondent. And in fact, the affidavit of the state respondents is under preparation and will be filed within
1 week.
1 week. Stop. Considering the submissions made by the learned counsels for the parties, that the matter be listed on 15th of July, 2026. The state respondents may consider making an alternative arrangement if the Learned Advocate General is unable to appear by the next date. Okay.
Let's launch.
Any more? Yes.
My lord. Lordship, if hearing item 18 can kindly be listed after the ensuing summer vacation, my lord.
18. Criminal appeal.
Yes, my lord.
You are the appellant, isn't it?
Yes, my lord. The appellant, he has already been enlarged on bail, lordship.
Okay.
Yes. Here there is an interesting issue, lordship, otherwise.
Mr. Santianger, Learned Counsel for the appellant, submits that the matter may be adjourned and will be listed again after the ensuing vacation. Stop. He submits that the appellant has also been enlarged on bail in the meantime. Stop the said prayer. is not opposed to by the learned counsel for the learned public prosecutor. Accordingly, matter stands adjourned to be listed again after the ensuing summer vacation.
My lord. In items 19 and 20, my lord, if it can kindly be fixed on 22nd of July 2026, I have consent of my learned friends as well. 22nd of July.
What is the auspicious date? 22nd of July. Okay. Mr. Sentianger, learned counsel, submits that he has some personal difficulties to conduct the matter today and prays that the matter be listed on 22nd of July 2026. The learned counsels appearing for the opposite parties also have no objection to the said prayer. In view of above, matter stands adjourned to be listed again on 22nd of July.
My lord.
Okay.
Lordship, in hearing item 44, if it can kindly be listed on 24th of June, which is next week, Lordship. I have the consent of my the public prosecutor.
Jail appeal.
44.
Okay, that's paid for by Mr. Sentianger. You are the amicus.
Yes, my lord.
None of the amicus carry appearing for the appellant and not opposed to by the other side. Matter stands adjourned to be listed again on 24th of June. All right.
Lordship, and in hearing items 32, 32, 34, and 35. Here, there is a review petition which is pending before the Chief Justice, which squarely covers the issue which is raised in this
32 to 37.
32, yes, in 36 and 37, I'm not appearing, my lord.
These are Lucas.
But it starts from 23.
Yes, my lord.
From 23, yes, it means.
Starts from 23 to 37.
Yes, my lord.
What are these matters?
Award charge regularization.
Work charge regularization.
Yes, my lord. In my case,
2015 OM.
Yes, my
Yes,
lord.
yes.
In my case, the writ petitions were allowed. In some of the matters, the writ petitions were dismissed. So, but
So what is to be done?
if it can kindly be,
After the disposal of the review petition,
Who has filed review?
when you,
my learned friend Supongwati has filed a review.
In which case?
Not in this case, lordship, but there is a review petition which is pending before the Chief Justice.
On the subject.
Yes, my lord.
But give us the number.
11 of 2025.
Review.
Yes, my lord. Review petition 11 of 2025.
In the principal seat.
My lord.
yes.
Arising out of? I mean, a review of which order? WPC number? Do you have that?
No, my lord. I don't have that.
WPC or WA?
WA, my lord.
WA.
Yes, my lord.
Can you have the number?
Yes, yes.
Sometime
I can provide.
you can provide.
Yes.
My lord.
Mm. Okay. It is submitted at the bar that review petition number 11 of 2025 on the same subject is pending consideration before the division bench,
My lord.
before the division bench led by the Honorable Chief Justice. Stop. The review petition arises out of writ appeal number so and so, huh? They'll give you the number. As such, adjournment has been sought of these matters and for listing the same after the disposal of the review petition. Next, para in view of above, these matters stands adjourned for the day. Adjourned to be listed again when?
After the disposal of review petition 11 of 2025, my lord.
But when we
Because
how do we know?
next date is fixed on 15th of July.
15th of July.
Yes, yes. For the review.
So we list it after that date.
Yes.
My lord.
Then you can inform
Sometime in August, my lord.
22nd.
On 29th of July, my lord, in that case.
Okay. It is also submitted that the review petition is scheduled to be listed on 15th of July 2026. In view of above, list these matters on 29th of July 2026. Parties are at liberty to make a mention about the status of the review petition.
My lord.
23 to 37.
My lord. Triply obliged.
Much
Okay.
May I please your lordship? I beg to mention item number 42 and 43.
42, 43, yes.
Yes, my lord. My senior Vyashu, who is leading the case, is indisposed, so please grant me 2 weeks time, my lords.
Who's your senior?
Vyashu Theo.
Sure. Is indisposed?
Yes, my lord.
What is your good name?
Kekiki.
Kiki, learned counsel, appearing for V. Theo. submits that Mr. Theo is indisposed and therefore prays that the matter may be adjourned for 2 weeks. Learned public prosecutor has no objection to the prayer. Will be above. Matter stands adjourned to be listed again after the ensuing summer vacation.
Obliged, my lords.
Matters have been adjourned.
Please, the lordships. Lordships, I beg to mention item number 11, lordship. Lordships, on the last occasion,
there is a violation of the procedural safeguards, Your Lordship. Under section 3(5) of the NSA Act, the detention order should have been intimated to the central government.
Just a minute. Give us that Bear Act, NSA. Section?
Section 3, subsection 5.
Please read.
Central government.
When any order is made or approved by the state government under this section, the state government shall within 7 days report the fact to the central government together with the grounds on which the order has been made and such other particulars as, in the opinion of the state government, have a bearing on the necessity for the order. Your Lordship, in my case, if we look at the affidavit in opposition filed by the Government Council, Your Lordships, in Annexure B, section, page number 11. The detainee in present case is in serial number 5, Ekivichishi, Your Lordships. And in the 5th column, whether government of India was intimated under section 3(5) of NSA, in that heading, it has been shown that the intimation was done on 2nd February 2026.
Yes.
So detention order was passed in 22nd January. And the intimation was done only on 2nd February 2026.
Provision says 7 days.
Yes, Your Lordships.
And this was beyond 7 days.
Yes, Your Lordships.
So for this, it has been vitiated.
Yes, Your Lordships.
Is it not possible to have beyond 7 days? Any exception?
Was the position of law, case law.
Yes, Your Lordships.
It has been held to be fatal, anything beyond 7 days. Limits are usually fatal. Limits are usually fatal. Preventive detention.
Your Lordship, I would like to rely on the case Herod Chung versus the state of Nagaland, Your Lordship.
Citation? No.
Two 2022 2 GLT 86.
Paragraph number?
I'm relying on para 17, Your Lordships. May I read for the court, Your Lordships? Para 17.
Yes, you may read.
A perusal of the said section would show that when an order is made or approved by the state government under section 3, the state government shall within 7 days report the fact to the central government together with the grounds on which the order has been made and such other particulars as in the opinion of the state government having a bearing on the necessity for the order. The record shows that on 27/9/2021, the order of detention was passed. There is no whisper in the affidavit in opposition filed by the respondent number 1, 2, and 4 as to when the said order of detention was communicated to the central government along with the grounds on which the order has been made and such other particulars as in the opinion of the state government having a bearing on the necessity for the order. The affidavit in opposition, more particularly in paragraph number 18, shows that only the approval order of detention dated 6/10/2021 along with relevant documents were forwarded to the central government on 6/10/2021. In absence of any materials placed before this court, it appears that the detention order dated 27/9/2021 was not communicated to the central government within the period of 7 days as is required under section 3(5) of the Act. Accordingly, the said detention order on the face of it violates the mandate of the section 3(5) of the Act. Lordships. Similarly, in our case, your lordships, the detention order was not communicated within 7 days.
Correct. You have a decision of a larger bench. This is a single bench. It may not be binding upon this court.
What is the position of the Honorable Supreme Court on this point? The 3.5 is violation of 3.5 is fatal. 3.5, the NSA is, if the mandate of 7 days violated.
Your lordship,
There must be some
as for now, I do not have.
We have to find that, right?
Yes, your lordships. Besides that, I'm also relying on other grounds also, your
I was
lordships.
just looking whether there is any reference to any Supreme Court decision in this judgment. Because it must have followed from there, most probably.
So the 7 days is for reporting together with grounds.
Yes, your lordships.
And in this judgment, what was communicated was approval.
Approval, yes, lordships. In our case also, approval was communicated, your lordships.
Only approval order of detention dated so and so, along with relevant documents were forwarded. So 27/9/21 and 6/10/21, these are also not very far away. About 10 days, I think.
Most probably, your lordships.
But the prescription is 7 days.
7 days.
And the word says the wording is shall.
Yes.
Shall. It's not may also. But this is a judgment by a single bench. Don't you have any Supreme Court decision on this?
As of now, your lordships, I'm not prepared with the Supreme Court decision.
You want to do some research? We'll grant you some time if you want.
Lordship, sufficient time has been given in this case. So if
No, supposing we don't accept your contention, then
if my other grounds,
you want to take your chance?
If my other grounds may be also heard.
Okay, what are the other grounds? What are the other grounds?
Lordship, in the affidavit in reply to the affidavit in opposition, Lordship, I've mentioned in para 6 that the detainee was prevented from making effective representation because the documents supplied to him, orders and other relevant documents were supplied to him in a language which he did not understand, which is in English.
Which paragraph?
Para 6, your lordships. Affidavit in reply to the affidavit in opposition.
Grounds in an unfamiliar language.
Yes, your lordships. The detention order, grounds of detention, schedule, approval order, all these have been supplied to the detainee in English, and the detainee is not conversant in English. It has been specifically mentioned in the schedule also.
He has read up to class 5.
Yes,
How do you say he's not conversant in English? I think he must be knowing.
Your lordship,
Everyone speaks very well good English.
he will not be able to understand all the documents which are voluminous in nature, your lordships. And I have authorities which I would like to rely regarding this ground also. Your
By the way, what is Article 222, clause 5? Give him the Constitution.
Grounds of detention, furnished.
Kumar is also going here and there. He is not. However, I thought he's not accepting. Constitution by right.
May I read for the court, your lordships?
This is court number 1. No constitution book in the court.
Go ahead.
Huh?
May I read it, lordships? When any person is detained in pursuance of an order made under any law providing for preventive detention, the authority making the order shall, as soon as may be, communicate to such person the grounds on which the order has been made and shall afford him the earliest opportunity of making a representation against the order.
So Vihan Kumar.
Vihan
Kumar also derived from this.
Yes, yes, your lordships.
This was in the
22(5).
preventive detention.
So this is your other ground.
Yes, your lordship.
Any other ground? It's also 2009 edition.
Lordship, may I be allowed to rely
They're
on
in
certain?
2026, Court Master. Court Master. Which year is this?
Little up to date.
You're giving us 2009 edition.
Keep,
You should keep it updated, okay? Yes. Then,
Lordship, I would like to rely on certain citations regarding this ground, your Lordships.
okay, yes.
In Mortuza Hussein Chowdhury versus State of Nagaland, the operative portion which I'm relying is in para 14.
Are you supplying us any?
Yes, we have
Okay.
already supplied your Lordships. Para 14, your Lordships. May I read your Lordships?
Yes.
Further, it is an admitted fact that neither Ashraf Hussein Chowdhury nor Adaliu Chawang knew English, the language in the orders of detention and the supporting documents. They specifically raised this issue in their individual representation dated so and so. The proposals for their detention also recorded that the only language known to Adaliu Chawang were Nagamis, Manipuri, and Hindi, while Ashraf Hussein Chowdhury knew Nagamis, Bengali, and Hindi. However, the authorities claim that the contents of the orders and the grounds of detention were explained to them in Nagamis and that the same would suffice. This argument must necessarily fail in the light of the law enunciated by a constitution bench in Hari Kisan Supra. Such oral communication, even if true, did not amount to adequate communication in terms of Article 22(5) of the Constitution.
Mr. Counsel, what is the judgment you just read?
I think it's a
Murtaza Hussain Chowdhury.
mixed up. I think this one was a bit.
I'm relying on two citations. This is the first one which I will.
No, we are not, we haven't given some other citation.
Lalu Bhai is a
This
different.
is Lalu Bhai Jogi Bhai Patel.
You may be relying. The reading is now from here.
Yes, Your Lordship. My apologies, Your Lordships.
Murtaza.
Para 14, Your Lordships.
Supreme Court of India.
You honor understands what Nagamis and what?
Nagamis and his local language, which is Sumi.
Okay.
Your Lordship, in the affidavit in opposition filed by the London government.
Nagamis, Manipuri and Hindi.
In this case, yes.
While Ashraf Hussain Chowdhury knew Nagamis, Bengali and Hindi. Authorized claimed that the order and explained to them in Nagamis and the same would suffice. This argument must necessarily fail in the light of the law enunciated in Constitution. You know, amount to adequate communication. What was there in Harkishan? Harkishan? Is it reflected anywhere?
Your Lordship,
Harkishan Supra. Where is Harkishan? Paragraph?
11.
Your Lordship, in Hari Kisan's case, which I'm not ready with the extra copies, but I have one copy which I may be allowed to read.
Yes, read.
Only the operative portion in para 7, Your Lordship. In our opinion, this was not sufficient compliance in this case with the requirements of the Constitution is laid down in clause 5 of Article 22. To a person who is not conversant with the English language, service of the order and the grounds of detention in English with their oral translation or explanation by the police officer serving them does not fulfill the requirements of the law, as has been explained by the court in the case of State of Bombay versus Atma Ram Sridhar Vaidya, clause 5 of Article 22 requires that the grounds of his detention should be made available to the detainee as soon as may be, and that the earliest opportunity of making a representation against the order should also be afforded to him. In order that the detainee should have the opportunity, it is not sufficient that he has been physically delivered the means of knowledge and which to make his representation. In order that the detainee should be in a position effectively to make his representation against the order, he should have knowledge of the grounds of detention, which are in the nature of the charge against him, setting out the kinds of prejudicial acts which the authorities attribute to him. Communication in this context must therefore mean imparting to the detainee sufficient knowledge of all the grounds on which the order of detention is based. In this case, the grounds are several and are based on numerous speeches said to have been made by the appellant himself on different occasions and different dates. Naturally, therefore, any oral translation or explanation given by the police officer serving those on the detainee would not amount to communicating the grounds. Communication in this context must mean bringing home to the detainee effective knowledge of the facts and circumstances on which the order of detention is based.
Then if you continue reading the subsequent paragraph, it also says, okay, this is of course in this Motuza.
Your Lordship, similarly in Lalubhai Jogibai, which I've supplied to this Honorable Court, Your Lordship, the same principle has been appreciated.
Lalubhai will be which para?
Para 20, Your Lordships. Lordships, in my case, in the affidavit in opposition filed by the learned government counsel, it has been specifically mentioned that the documents were supplied to him and explained to him in the language Nagamis, which he understands. But as per the authorities, Your Lordships, that itself would not suffice, Your Lordships.
It has been explained to him.
Explained to him, yes, Your Lordship.
Verbally, but not given in.
Yes, Your
But
Lordship.
he doesn't
Not given.
understand Nagamis.
Yes. He understands Nagamis,
But
not English, Your Lordships.
not English.
All the documents were supplied in English.
He's a literate person.
Your Lordships.
He's a literate person.
No. He's not a literate person. He read only up to class 5.
He's literate up to class 5.
Five only,
Then
Your
it
Lordships.
was, even it was given in Nagamis, in written Nagamis. Then he was
Not in that also he would not be able to understand Your
He has to
Lordships.
be explained verbally in Nagamis, right?
Your Lordships.
But that
Maybe in his local language, in Sumi, he may be able to understand Your Lordships.
Yes. What else?
Your Lordship, besides that, Your Lordship, the affidavit has been has not been filed by the detaining authority, but totally different person, Your Lordship. Affidavit in opposition, Your Lordships.
Is there any mandate?
This I have mentioned in my affidavit in reply, para 3, Your Lordships.
No, is there any requirement that it is only but the detaining authority who should file the affidavit?
Yes, for subjective satisfaction, for explaining the subjective satisfaction, it should be the detaining authority who should file the affidavit.
Yes.
For this, I would like to rely on certain authority. Lordship, Ananta Gogoi versus Union of India.
Yes. Para?
Para 19, Your Lordships. May I read?
lots of the subjective satisfaction.
An ordinary reading of the above paragraph of the affidavit would go to clearly depict that the deponent is not competent to speak about the subjective satisfaction of the detaining authority. It is accepted that the affidavit in opposition must come from the detaining authority. Surprisingly, there is not even a whisper as to why the detaining authority who issued the impugned detention order could not file a response. Thereapart, how can the office order dated so-and-so issued by another officer, not being the detaining authority, be accepted as being authorization letter to file the affidavit by the additional deputy commissioner? There cannot be a better example of non-application of mind, mechanical approach, and a cavalier attitude shown by the state than the case at hand.
The first part, you have also given the same ground in your reply affidavit.
Yes, your lordships.
Subjective satisfaction.
Yes, lordships.
So since it is subjective satisfaction, that is your contention.
Yes, I have.
Since it is
I
subjective.
challenged that also, your lordship.
Mine, so I have to file the affidavit.
Yes, your lordships. But that has not been done in this case. In fact, the individual who is not even made a party to this particular case was made to file the affidavit, your lordships.
There's no line anywhere in the affidavit saying that he has been authorized.
No, not even a whisper, your
In
lordship.
Ananta Gogoi, there is an authorization, but not by the person who detained it, but
Yes.
somebody else.
Yes, your lordships. I have another citations, your lordship, which I'd like to rely.
This is.
This is by the division bench, your lordships. Adam Ali versus Union of India.
Paragraph?
Paragraph 24, your lordships.
This is on which point?
On same ground, your lordships. That affidavit should be filed by the detaining authorities. May I read, your lordships?
Yes.
We have also noticed an important factor in this case which is that the counter affidavit has not been filed by the authority which had passed the detention order, that is District Magistrate of Dhubri, but the same has been filed by the Additional Deputy Commissioner. There is no explanation in the affidavit as to what prevented the District Magistrate from filing his own affidavit in the present case, since he was the authority on whose subjective satisfaction the petitioner was detained. This has been dealt with by a division bench of this court in the case of Pukhan Daimari, Phungjarang versus State of Assam. As in the said case, the authority who has detained a person has not explained her subjective satisfaction before this court. An affidavit by any other person, save and except the person who has passed the detention order, is no explanation of subjective satisfaction. In my petition, I have put a challenge that there is no subjective satisfaction. But in order to explain that the detaining authority should have filed the affidavit, but in this case, it has not been done, some your lordships.
All right. What else?
Your lordship, in para 8 of my affidavit in reply, your lordships, I've made a contention that
Para?
para 8, your lordships. Your lordship, my apologies, para 7. The grounds of detention provided is, firstly, the security of the state of Nagaland. Secondly, the public order. That is the grounds of detention relied by the detaining authority. But I'm contending that there is no explanation as to in what manner the action of the detainee affects the security of the state of Nagaland, your lordships. The offense charged against him and the grounds of detention does not tally, your lordships. It's vague and there is no explanation, your lordships. It has been specifically admitted, even in this affidavit filed by the learned counsel for the government respondents, your lordship. In para 5, page number 5, your lordship. Para 5 continuation, page number 5 of my affidavit in reply.
See, apart from security of state, what was the other ground?
Public order, Your Lordships.
Public order.
Maintenance of public order.
Okay.
In my petition, I have put a challenge to these 2 grounds also.
Para 5.
Yes, Your Lordship. Para 5, the next page, page number 5, Your Lordship. I've contended that the respondents have specifically admitted that the case of the detainee is purely maintenance of law and order in the state. This has been specifically mentioned in the affidavit in opposition. So there is no question of maintenance of public order or security of the state of Nagaland, Your Lordship. It's just a mere statement, ipse dixit, and non-application of mine, Your Lordship. There is no subjective satisfaction with all, Your Lordships. Lordship, these are the humble grounds on which I'm challenging the detention and the consequential, all the consequential orders, Your Lordships.
That's all?
Yes, Your Lordships.
That's all.
Yeah, please, Lordship. My lord, in regard to ground number 1, my lord. In regard to, Your Lordship, may kindly see the NSA. NSA, page number, NSA section 3, clause 3.
Yes.
May I read, my lord? Section 3. Section 3, clause 3.
Clause 3?
Yes, my lord. NSA, my lord, detention order was passed under this section. Clause 3, section 3, clause 3. If having regard to the circumstances prevailing or likely to prevail in any area within the local limits of the jurisdiction of a district magistrate or commissioner of police, the state government is satisfied that it is necessary to do so. It may by order in writing direct that during such period as may be specified in order, such district magistrate or commissioner of police may also, if satisfied as provided in subsection 2, exercise the power conferred by the said subsection, provided that the period specified in an order made by the state government under this subsection shall not in first instance exceed 3 months, but the state government may, if satisfied as aforesaid that it is necessary so to do, amend such order to extend such period from time to time by any period not exceeding 3 months at any one time. Clause 4. When any order is made under this section by an order mentioned of an officer mentioned in subsection 3, he shall forthwith report the fact to the state government to which he is subordinate, together with the grounds on which the order has been made, and such order, particular as in his opinion, have a bearing on the matter, and no such order shall remain in force for more than 12 days. After the making thereof, unless in the meantime it has been approved by the state government. My lord, section 4, section 3, clause 4 is very clear that detention order dated 22/1/2026 to 26 is valid for 12 days only, subject to approval under clause 5. Clause 5, it says, when any order is made or approved by the state government under this section, the state government shall, within 7 days, report the fact to the central government together with the ground on which the order has to be made. And such other particulars as in the opinion of the state government have a bearing on the necessary for the order. My lord, here, the procedure is very clear that detaining authority will pass the detention order under section 3, clause 3, and that order is valid for 12 days. That is under section subclause 4. And my lord, that detention order will forward it to the state government, and then the state government will approve under subclause 5.
And within 7 days.
And within 7 days, it will communicate to the central government. So, my lord, after approval only, that detention order will be communicated to the
First 15 days,
Yes.
then after 7 days.
Yes. So, forwarded to the Union of India. And my lord, here it's very clear that detention order was passed on 22/01/2026, and it was approved by the state government on 02/02/2026. Approval order.
No. Approval order is 31/26.
No, my lord. Your lordship may kindly see the annexure, my lord.
Come to annexure B, page 11 of your affidavit in opposition. Serial number 5 is the petitioner, detainee. Then against date of approval, column 1, 2, 3, 4th column. It says what? 31/26. Intimation to government, central government is 2/2/26. Anyhow, it's within 7 days. Have you got it? Your
Yes,
affidavit in opposition.
my lord. Here, my lord. Actually, that in the annexure, in the writ petition, the date is 02/2026.
But see the top.
So, my lord, here in the.
What is that column for?
Yes.
Whether government of India was intimated under section 3(5) of the NSA. Intimation date is 2/2/26.
Yes.
What is the date of approval? It is different.
31/2026.
Oh, that's what.
My lord, it might be typing mistake, my lord, because the
How?
lordship McCartney, the writ petition. In the writ petition, the approval order is 02/02/2026. Your lordship McCartney, see page number 50 and excerpt 9.
Where's the approval? Which para? It has approved the detention.
Date.
2/2/26.
Yes, 2/2/2026.
Then what is the date of communication then?
It was communicated on
same day.
No, yes, 2/2/2026 on the same day.
So something wrong with this annexure B.
Yes, my lord. Here.
It was duly signed by the special secretary.
It should be 2/2, that approval order should be 2/2/2026. So, my lord, here my submission is there is no violation on time.
Okay.
The detention order was communicated to the Union of India. That is my first submission in regard to this first ground. My lord, in regard to detention, grounds of detention not explained to the detainee in the language he understands, my lord. In this regard, my lord, your lordship may kindly see my affidavit.
Yes.
Page number 10, annexure A. acknowledgement certificate. Married, my lord. I, Mr. So-and-so, son of so-and-so, and president of so-and-so, acknowledge receipt of one set of detention order dated 02/02/2026 and its enclosure, and certify that the contents have been explained to me in the language I understand. That is the Nakamis. In the presence of the undersigned witnesses. So, my lord, detention has been explained to the detainer in the language you understand. That is the Nakamis. And my lord, in regard to crown number 3.
Yes, ground number 3.
Ground number 3. Affidavit in opposition not filed by the detaining authority, my lord. Your lordship may kindly see the affidavit in opposition. Affidavit in opposition was filed on behalf of respondent number 1, 2, 3, and 4. It was duly authorized to the deponent to file this affidavit, my lord. And my lord, detaining authority, the detention order was passed by the commissioner of police, that is the district magistrate. And subsequently, it was approved by the state government. So, my lord, here, your lordship may kindly appreciate that while approving the detention order, the authority should first satisfy himself, my lord. So, my lord, here, the documents and the facts of facts basing on the facts and circumstances of the case, that the detaining authority, the approval authority has passed the approval order, and so the authority has a right to has the authority to file this affidavit, my lord. What I mean to submit is that
approval is given by whom?
By the chief secretary, my lord.
Affidavit is filed by the Home Commissioner.
Yes, my lord.
So it is not the chief secretary who has filed it. You are saying that approval is given only on subjective satisfaction. So if the approval authority who gives the approval has filed the affidavit, there's nothing wrong. Approval is given by the chief secretary, affidavit filed by the Home Commissioner. Then where is the authorization?
Authorization, my lord, in the para 1, it clearly says that your lordship may kindly see the para 1 in my affidavit.
It is not clear, that's why you read. Please read.
I am also familiar with the facts and circumstances of the present case, and being duly authorized, I am competent to swear this affidavit on behalf of the state respondent.
Authorized by whom?
By the state government.
The more specific.
The chief secretary and the commissioner of police.
Specific mention in fact.
My lord, it is not necessary that the detaining authority, that the order which was passed by the detaining authority is valid for only 12 days and subsequently subject to approval by the state government. So state government can also file affidavit in regard to the subjective citizen claim.
Now, when you say authorized, is there any document authorizing him?
No, man.
Then make it just a statement, I'm authorized, I'm filing it. Will it be sufficient? This is normally what is done in your writ petition also. Duly authorized, I'm filing it and all that.
Yeah.
But is there any authorization? Practically, it is not there, isn't it?
Yes.
It's only a statement.
Yes, my lord.
Now we are talking about detention law. We have to be very specific.
Yes, ma'am.
Standard will be higher.
Standard will be higher.
That authorization is not here. And my lord, fourthly, in regard to the subjective satisfaction, my lord. On the fourth ground, my lord.
Yes.
Your lordship may kindly see the grounds of detention, my lord. In the writ petition. Writ petition, page number 41. The subjective satisfaction has been explained under this schedule, madam. Page number 41.
41 is a continuation of what? Which schedule?
Yes, my lord.
Schedule is attached to what?
Grounds of detention, my lord.
And grounds of detention will be a part of?
Part of detention order.
And detention order starts at page 33.
Yes, my lord.
Grounds of detention, then schedule.
Page number 41.
41.
Para 2, 3, and 4. Mary, my lord. Para 2. That the subject stated that he was born and brought up from Sunito village and he studied from Joseph School, Kohima till class 5. In the year 2014, he got married and has 3 sons.
Just a minute.
He joined.
Is it 41, but it's not telling with our copy.
Read petition, my lord. Read page number 41.
Read petition. Correct. 41, you are saying second para. Second para.
Para 2. The last at the bottom.
Numbered para.
Yes.
Last para.
Last paragraph, my lord.
Last paragraph.
Yes.
You may read.
That the subject stated that he was born and brought up from Sunito village and he studied from Joseph School, Kohima till class 5. In the year 2014, he got married and has 3 sons. He joined NSNR's faction in the year 2020 in the rank of lessee. He left NSNR, he joined NSN Kangmo in the year 2024 and currently serving in the rank lessee of crime branch civil wing.
What is lessee? Lessee rank? Any explanation for that?
There's no explanation.
You should have some explanation.
That explanation is not given, Mary.
I mean, generally you don't have any answer for that lessee. When you say lessee, like in the armed forces, in the government.
No,
the constable,
they are the underground, so he is active member of NSN Armalo.
Not that. And when it say that he in the rank of lessee,
yes.
This rank of lessee is equivalent to which rank in the Indian Armed Forces? Any idea?
No idea. No idea.
Because this will have a bearing in the kind of projection that he is illiterate, does not know. You can also come up with this argument saying that he is a lessee. He's supposed to know so many things. In the crime branch, civil wing. We are just exploring.
My lord, I'm informed that and the rank of MLA.
MLA?
Yes, my lord.
Okay.
Yes. Para 3, my lord. That as per records made available by the sponsoring authority, the subject is active member of NSN Kango, serving in the capacity of lessee. The subject, along with other accomplices, had abducted the victims and also threatened the victims using automatic weapons and demanded ransom money of rupees 50 lakhs for the release of the abducted victims, thus acting in a manner prejudicial to the maintenance of public order and security of the state. The subjects are likely to move for bail and enlarging them on bail, increasing the possibility of the subjects indulging in other criminal activities. Thus, there is every possibility of the subject indulging in similar prejudicial activities, which will be detrimental in the maintenance of public order and have the potential to vitiate the peaceful environment. The incident has also attracted massive public outrage and media attention as the incident had occurred in residential village, vitiating the peaceful environment. Para 4. The subject so-and-so is presently under judicial custody at Central Jail, Dimapur, and has moved for bail on 21/2026. If he is not detained, he is likely to indulge in similar prejudicial activities unless an effective and alternative measure is called for. On examination of the report forwarded by the sponsoring authority, the subject is found fit to be booked under National Security Act 1980. Hence, in order to prevent him from indulging in activities prejudicial to the security of the state of Nagaland and maintenance of the public order, the undersigned has ordered the detention of the subject under the said act. My lord, this is the subjective satisfaction explained by the detaining authority. And basing on this, the state government has approved the detention order.
But since he was in custody, another factor.
Yes.
He was in custody, and yet the detaining authority had to be satisfied about the possibility of his release.
Yes, my
on
lord.
bail, right?
My lord, because
leading judgments on that Supreme
Yes.
Court, isn't it?
Yes.
That mere filing a bail may not lead to release, but whatever it is, have to brush up. The authority has to be satisfied about real possibility of release. Then it will be justified to preventively detain a person who is already in judicial custody, right?
Yes. So, my lord, my humble submission is there is no violation, there is no lapses in the procedural specified under the Act, and the detention order passed by the detaining authority is justified and according to the law, man. So, this petition should not be allowed. That is my humble submission.
It's still when the detention now, the latest, it's up to 21/7.
July.
Yes.
All case falls, because we say level into Govinda. When you say Govinda, you have to be at least multiple. But for another degree, you have no prescription. You don't have to have any qualifications as well.
For
Your Lordships, may I point out an important point in the affidavit in opposition filed by my learned friend?
Just a minute, Mr. Form, you have finished?
Yes, my lord.
Anything else? That's all?
Yes.
Lordship, in the affidavit in opposition filed by my learned friend in para 4, the continuation of which is in para page number 4. Starting from the 6th line, your Lordships.
Yes.
The detainee Mr. Krakivichishi, SS Lacey and SCNK Kango was arrested for carrying out kidnapping, abduction for ransom. Lordship, specifically, it has been mentioned that this is a case of kidnapping, abduction for ransom, which can be dealt by ordinary court of law. And preventive detention is not necessary, your Lordship, in this case. And further, when we read, your Lordship, that such covered illegal activities are of great concern for the general public and a threat to the public security, adversely affecting the economic development of the state and detrimental to the tranquility and maintenance of law and order. Law and order, your Lordship. They have specifically admitted that this is an issue of law and order, not maintenance of public order, your Lordship.
Kidnapping for ransom is highly detrimental to economic environment. It's very true. It's very true, generally.
Your Lordship, but they have specifically admitted that it is an issue of law and order, not of public order, your Lordship. There is a huge difference, your Lordship. So there is no subjective satisfaction. The grounds of detention has been merely passed without application of mind. And this has not been explained by the detaining authority as well, your Lordship, since no affidavit has been filed. And as far as the contention, the submission raised by my learned friend, I beg to differ in that point as regard to section 3, subsection 345, which has been read out to this honorable court, your Lordship.
Yes.
In subsection 4, your Lordship, when we read the relevant portion, it mentions that when any order is made under this section by an officer mentioned in subsection 3, he shall forthwith report the fact to the state government to which he is subordinate, together with the grounds on which the order has been made and such other particular as, in his opinion, have a bearing on the matter, and no such order shall remain in force for more than 12 days. This talks about a totally different issue, Your Lordship. And when it come to subsection 5, Your Lordship, it talks about communicating, intimating to the central government within 7 days, Your Lordship. Subsection 4 talks about the order to be remain in force. And subsection 5 talks about communicating the order to the central government, Your Lordship. So these are two different sections. It cannot be read together, Your Lordships.
But the first line, it says, when an order is made or approval by the state government under this section.
So approval time is 15 days.
Yes, my lord. My lord, the learned friend is misinterpreting the section, my lord. See, my lord.
He's trying his best to convince the court in that way.
Your Lordship, because in the first line.
We understand. He's saying that at any rate, the order has to be communicated within 7 days, irrespective of whether it's 3 or 4. But you're saying that the arrest was made under 3 and under 4, there's 12 days. Then once that 12 days, within that 12 days, that approval is to be given, and after approval, 7 days time. 7 day, the approval was given on 2nd of February.
Yes.
Same day it was communicated.
Yes.
There's no delay.
No delay.
We'll consider. So are you done?
Yes, Your Lordship.
Okay. We'll come back.
Lordships.
In 5 minutes. Okay. Third, Mr.
Zakapo Chishi, your lordships.
Zakato Chishi, learned counsel for the petitioner, and Mr.
E.T. Bapong.
E.T. Bapong, learned public prosecutor.
Yes.
For the state. Parties have made their respective submissions. Orders to be passed separately. In order to save time, we'll not pass order now, later. Okay.
For orders.
Obliged. Much obliged.
For orders, item number 13.
This one is right.
Please, Your Lordship.
Yes.
Lordships, the petitioner herein is the wife of the detainee. And she is seeking to quash and set aside the detention order dated 8 April 2026 and the approval order dated 16/4/2026. And the ground on which she is seeking to quash aside the detention order is at part 10 of my
First,
petition, my
you
lord.
show us where's the detention order?
25, page number 25, my lord.
25.
Yes, my lord.
Please read the order, please.
Yes, my lord.
Please read the order.
My lord. Whereas Vikachopi, 40 years, SS Joint Secretary, NSCN Congo, son of Ketobi, Chopi, village Ayemi, Seroto, Zenepoto, Naga United Village in Kidima, was arrested in connection with DPRSC NO 004/26 under section 351 3082 131 1427 subclause 2 35111 113 BNS read with section 7, 8 NSR, section 16 and 18 of the UAP Act. And whereas I, the Commissioner of Police Dimapur, Srimati Autula I. Imchan, is satisfied that in view to prevent the above accused from acting in any manner prejudice shall to the security of the state of Nagaland and to maintain public order, it is necessary to detain him under subsection 2 of section 3 of the NSA 1980.
Okay. Next is the ground of detention, then you have the schedule.
Yes, my lord.
Then where is the
Approval order is at page number 37, my lord.
37?
Yes, my lord. Annexure F.
37 and Annexure F.
Yeah.
The approval order. It has approved the detention order of the Commissioner of Police to detain. Excise of part 3-2. 3-2, what is 3-2? Detention, okay.
Yes, my lord.
Then?
So, my lord, I'm seeking representation dated 14/4/2026, my lord.
What is Annexure G, page 38?
Annexure G, page 38 is the order of
rejecting the representation.
Yes, my lord.
And your representation is at?
Representation is at page number 30, my lord. 30.
The 30 is only a receipt.
Yes, my lord. It starts from 30, my lord. Once I file my representation, this receipt is given to me by the jail authorities.
How have you made this presentation?
Yes, my lord.
Through the jail authorities?
Yes, my lord.
Special Secretary Home. It says through proper channel. What is the channel otherwise? It is submitted to the superintendent.
Yes, my lord.
Superintendent of jail.
Superintendent of jail, then
Who will forward it to the,
he forwards it to the various authorities,
okay,
to the central government, the state government, the detaining authority, the advisory board.
now when does the advisory board step in? At what stage?
My lord, within 3 weeks, the reports are to be submitted to the advisory board.
Advisory board.
As per section 10 of the NSA.
Okay,
My recommendation has to be submitted to the advisory board within 3 weeks from the date of detention.
okay.
Then the advisory board is to file the report within 7 weeks from the date of detention.
Okay.
Yes, my lord.
Then your representation is to be considered by the board only.
No, by all the authorities,
By
by,
the
the detaining authority, the state, the central, and the advisory board also.
So who will accept or reject your representation then ultimately?
My lord, all authorities, the detaining authority, the state government, and the central government, my lord.
So they'll all take their own separate calls
Yes, my lord.
separately.
Yes, my lord. As per section 14 of the NSA, they all have authorities to reject or my recommendation, my lord.
Then, but as per conflict, if there's conflict, then what happens?
My lord,
Serially.
no, my lord, they are to take their steps independently, my lord.
Your representation does not have any date.
My lord, it is dated 14, my lord.
Where do you say that? How do you say that?
The receipt, my lord, at page 30, Annex E, my lord.
Or from the receipt?
Yes, my lord, 14-4. This is the receipt which is given to me by the jail authorities. Once I file my recommendation.
Then on 16/4, detention is approved.
Yes, my lord.
Then when was your representation rejected?
20, my lord.
20
April by the state government.
20 April.
Yes, my lord. At page number 38, Annex G. And by the central government on 28 April 2026, page number 39, my lord. By the central government. However, till date, the detaining authority has not disposed of my representation, my lord. The detaining authority has not disposed of my representation till date.
Who is the detaining authority?
The police commissioner and the district magistrate Dimapur.
Representation was filed before approval, isn't it?
Yes, my lord. It was filed before approval, and I've served it to
Now,
all the
now
authorities.
supposing the government has approved it and the Union of India has also approved it, ministry. What will the commissioner say now?
My lord, then the commissioner will not have any authority.
That's why you say it has not been disposed of till now.
Yes, my lord.
Is it?
My lord, but my representation was filed before the approval. So it is bounded, he is bounded under Article 225, Article 22 subclause 5 to dispose of my representation. I have filed my representation before the approval order came.
Before the approval?
Yes, and it was the detaining authority who informed me to file my representation before the detaining authority. If I may kindly take my lord to page number 26, my lord, page number 26. Page number 26, the last para, my lord. May I read, my lord? Page number 26, my lord.
Yes.
You are also informed that you have a right to make representation to the detaining authority, central government, and the state government through the concerned jail authorities, my lord. So it was the detaining authority who informed me that I have a right to make my representation as per Article 22 subclause 5, and thereafter I made my representation. Having made my representation, the detaining authority has still did not dispose of my representation, my lord. Has never disposed of my representation, my lord. Therefore, on this ground also, I am seeking for revocation of my detention order, my lord.
Commissioner of Police, isn't it?
Yes, my lord.
And who else is there? Who has not disposed of?
The advisory board, my lord.
Advisory board.
Yes, my lord. I'm not aware because I have not been communicated with any documents to state that they have disposed of my recommendation, despite me making a recommendation to the advisory board. And as per section 10, I have a right to put up my recommendation before the advisory board, my lord.
So tell us your grounds then.
My lord, my first ground is that there is nothing in the detention order to show that I'm likely to be released on bail, my lord. There is no mention in the detention order dated 8 April 2026 that I'm likely to be released on bail, my lord. And furthermore, my lord, I've been booked under section 16 and 18 of the UAPA Act. 16 and 18 of the UAPA Act. And as per section 43D subclause 5, my lord, it is next to impossible for me to get bail. It is next to impossible for me to get bail, my lord.
Section?
I've been booked under section 16 and 18 of the UAPA Act. And as per section 43D subclause 5 in the proviso, it is married, my lord.
Yes.
Provided that such accused persons shall not be released on bail or on his own bond if the court, on perusal of the case diary or the report made under section 173 of the court, is of the opinion.
Very
difficult. Prima facie grounds are biblical. If prima facie grounds are there, bail cannot be given. Is of the opinion that there are reasonable grounds for believing that the accusation against the person is prima facie true. And I've been named the FIR, my lord. So it is next to impossible for me to get bail. So the detaining authority has mechanically passed the detention order without any application of mine. Section 16 and 18 of the UAPA falls under chapter 4, my lord. Yes.
Section 4 and 6 sections,
16 and
that proviso applies.
Yes, my lord.
Sections under section, chapter 4 and 6 of
Yes,
the
my lord.
UAPA.
Yes, my lord.
That restriction on bail applies.
Yes, my lord.
In terms of 43(3)(5).
My lord. Yes. So it's next to impossible for me to get bail, my lord.
Possible, but if they are primary facie materials, then it is difficult.
And I've been named in the FIR. So there is no chance for me
There has to be
get bail.
primary facie materials.
Yes, my lord.
To bring that restriction.
So there was no subjective satisfaction while passing the detention order, my lord.
Yes. What else?
So my next condition, my lord, is that I have been informed by the detaining authority that I have a right to make a representation. And as per Article 22, subclause 5, I have a right to make a representation to the detaining authority, who is the Commissioner of Police Dimapur and the District Magistrate Dimapur. And I've made my representation before the approval. That is representation dated 14/4/2026. However, till date, the detaining authority has not disposed of my representation. And my lord, to support my contention, kindly allow me to rely on a citation of this honorable court. In the matter of Anteman Mina versus District Magistrate Imphal East and others. My lord, I have marked the relevant portion for the convenience of this honorable court at para 20, my lord. Married, my lord.
Para T.
Yes, my lord. Page number 9, my lord. Page number 9, para 20. Married, my lord.
Yes. Also.
Yes, my lord.
Read.
More so, the Supreme Court, in elaborating the scope of Article 22(5) of the Constitution, in Kalmeshwar Kumar case Supra in para 14 of page 59 observe as follows. Article 22(5) must therefore be construed to mean that The person detained has a right to make a representation against the order of detention, which can be made not only to the advisory board, but also to the detaining authority. This is the authority that has made the detention order or the order for continuance of such detention, which is competent to give immediate relief by revoking this said order, as well as to any other authority which is competent under law to revoke the order for detention and thereby give relief to the person detained. This right to make a representation carries within it a corresponding obligation on the authority making the order of detention to inform the person detained of his right to make a representation against the order of detention to the authority who are required to consider such a representation, my lord. And thereafter, my lord, at para 24, my lord. Non-consideration of the representation dated 31/03/03 by the detaining authority, respondent number 1, is hit by the fundamental right guaranteed by the Constitution of India under Article 22(5) of the Constitution and makes the detention of the petitioner illegal, my lord. And here also, my lord, the detainee was, in this case, in the present case, the detainee was detained on 24/03/2003. And thereafter, representation was made on 31/03/2003. And the government approved the detention on 03/04/2003, my lord. However, since the detaining authority failed to dispose of the representation dated 31/03/2003, the detention order was revoked, my lord. Then, my lord, my next ground is that the detention order was passed on 8 April 2026. The state government ought to have made the reference to the advisory board on or before 29/04/2026.
Yes, please come again. You were saying?
Yes, my lord. My next contention is that the detention order was passed on 8 April 2026. So as per section 10 of the NSA, within 3 weeks, the state government ought to have placed my representation before the advisory board. Within 3 weeks. So that is on 29/04/2026. By latest, they should have placed my representation and the order of detention before the advisory board. However, my lord, the advisory board was constituted only on 02/05/2026. And the same is a gross violation of section 10 of the National Security Act, my lord.
It was constituted on
02/05/2026.
2nd May.
That is when the board said, my lord.
So it was considered after this period.
Yes, after 2 weeks. So it has to be considered before 3 weeks. My representation given to the advisory board has to be taken into consideration before 2 weeks, my lord.
What is 8/4/26 date?
Yes, my lord.
8/4?
8/4/26 is the date of detention, my lord.
Detention.
Date of detention.
Yes, my lord.
So from that date, 3 weeks.
3 weeks, my lord. If I file a representation, it should be placed before the advisory board within 3 weeks, my lord. As per section 10
Your
of the.
presentation is 14/4.
Yes, my lord.
14/4 to 2nd of May. How many weeks?
No, my lord, from the date of detention, my lord.
From the date of
From the
detention.
date of detention, my lord. From the date of detention, not from the date of my representation, my lord. My lord, in the affidavit in opposition, the government has given one annexure.
Yes, what is that?
In the affidavit in opposition of the state respondents, they have enclosed one annexure A,
Affidavit of which response?
respondent number 5, my lord. 5. Yes, my lord.
Page.
Page number 14. Here it is stated that the copies of detention order, grounds of detention, and other relevant documents are sent herewith to the Honorable Justice Esupatosu, Chairman NSA, my lord. But my lord, my humble submission is that the advisory board consists of the chairman and 2 other members, not the chairman alone. And it should, as per the strict reading of this section 10 of the NSA, it clearly states that it should be placed before the advisory board. My representation in any other orders, if any, should be placed before the advisory board.
So below that, copy 2 with 3 sets documents for members.
Whether it is being placed before the advisory board, it is being sent to the chairman, maybe, my lord, maybe. But it was only placed before the advisory board. Advisory board is not the chairman. Chairman is not the advisory board. Chairman consists of the advisory board consists of the chairman and 2 other members, my lord. So it was placed before the advisory board only on 02/05/2026.
Advisory board has taken any decision?
My lord, I'm not aware of that.
You're not aware?
I have not been communicated.
Affidavit of opposition does not contain any.
No, my lord.
State cannot answer for the advisory board, Your Lordship.
Sorry?
I'm only for the state respondents,
Okay.
not for the advisory board.
But still, have you disclosed any information regarding what has happened to the advisory board's
No, Your Lordship.
opinion?
I have not been given any
Okay.
information on it.
But the advisory board is not a party. That way, you're saying that I'm not for the advisory board.
They have been made a party.
Huh?
Yeah.
They made a party?
Yes, my lord.
And then who's appearing for advisory board?
My lord, it is the state who appears. Usually it is the state who appears in all other cases. The state cannot deny liability here. It is the state who appears. There is no separate counsel for the advisory board.
Correct. You have to appear for all of them, 1 to 6. No, of course, except for 2. 2 is Union of India.
Yes, my lord.
1, 3, 4, 5, 6.
So, my lord, my last contention is that I've been booked under appropriate provisional of law, like the BNS and the UPA and NSR. And under UAPA, it's next to impossible for me to get bail. So detention order was passed mechanically without any application of mine, and it deserved to be questioned set aside. And with the detention order, it has violated my Article 21 also, my lord. I cannot go for trial and prove my innocence, my lord. Therefore, my humble submission is that the detention order dated 8 April 2024 and the approval order dated 16/4/2024 be questioned set aside, my lord. That is my humble submission, my lord.
Okay. Yes. Any citation?
Yes, my lord, to support my contention that advisory board should sit within 3 weeks. And if the advisory board, my representation is not placed before the advisory board within 2 weeks, then the detention has to be caution set aside, my lord. At para 24 and 25, my lord, the relevant portions. I've marked. This is para 24 and 25, my lord.
Anything else?
My lord, that is my humble submission, my lord.
Okay. PP?
Yeah, please, your lordship. Lordship, with regards to the mention of subjective satisfaction, whether bail was likely to be granted, your lordship. I would like to mention that the detenue has been identified as a member of a faction. He's the joint secretary. And this case is about kidnapping and on ransom. So if I may take you to page number 29 of the petition, your lordship. Just for brevity, I won't go to the facts of the case, your lordship. But the crux is that I would like to read from the fifth para, your lordship. In view of the aforementioned facts, have you got it, your lordship?
Yes.
Yes. In view of the aforementioned facts, accused persons such and such, and the detenue is reflected at A9. We were arrested for the organized nature of the crime. The group is a ceasefire signatory group directly involved in violent civilian abduction and the imminent threat to public order and state security. Moreover, being a member of such an armed organization outfit, such criminal acts and activities are a threat to public security, adversely affects the economic development of a state, and detrimental to the tranquility and maintenance of law and order in the state. The actions of the subject persons constitute a direct and deliberate challenge to the sovereignty of the state and the rule of law. This is evidenced by grave prejudice to public order and tranquility. The brazen abduction of a civilian from his place of work by an armed UG group creates widespread fear and terror in the business community and public at large, severely disrupting public order. Direct affront of state sovereignty and monopoly on justice. The act of running a parallel crime cell and summoning abducting citizens is a direct challenge to the lawful authority of the state and its judicial police missionaries. Violation of ceasefire ground rules and agreements. The use of a ceasefire supervisory board office, a designated camp under a ceasefire agreement, and as a base for planning, executing, and concluding a criminal abduction is an egregious violation of agreed ground rules, violating the peace process. Organized criminal conspiracy. The involvement of multiple high-ranking functionaries, finance, defense, kilonsers, indicates a planned organized conspiracy by the faction, not a rogue act by individuals. High likelihood of continual criminal activity and obstruction of justice. 3 accused. The first is the detenue lordship, Vika Choppy, remain absconding. The arrested individuals are senior leaders whose release on ordinary bail would allow them to continue their unlawful activities, intimidate witnesses, and threaten the victim and his family. Inadequacy of ordinary legal remedies necessitating preventive detention. While a strong criminal case exists, the pace of trial and possibility of bail do not adequately address the immediate and continuing threat these individuals pose to state security and public order. Preventive detention is necessary to break the cycle of violence and coercion. In view of the above facts, preventive detention under NSA Act 1980 is deemed necessary to prevent further criminal activities of the organized crime and to further prevent disturbance to public order. That the subject, Vika Choppy, self-styled Joint Secretary NSN Council, is presently under judicial custody at Central Jail Dimapur and has moved bail on 6/4/2026. If he is not detained, he is likely to indulge in similar prejudicial activities unless an effective alternative measure is called for. On examination of the report forwarded by the sponsoring authority, the subject is found fit to be booked under the National Security Act 1980. Hence, in order to prevent him from indulging in activities prejudicial to the security of the state and maintenance of the public order, the undersigned has ordered the detention order of the subject and under the said act. So, Your Lordship, this detention order was issued after giving due consideration to all the facts and records placed before the authority, Your Lordship. On the grounds of the representation not been disposed by the detaining authority, Your Lordship, the government has already properly disposed of the representation, and the matter has been forwarded to the government for approval. So the disposal of representation by the government would suffice, Your Lordship. The disposal by the detaining authority would not be a requirement, Your Lordship. And as far as the grounds, the third ground that the petitioner has said that the representation was not produced to the advisory board on time, Your Lordship, the annexure I have annexed in my petition clearly shows that it was placed before the detaining authority well before time on 16/4/26 on page 14 of my affidavit in opposition, Your Lordship, which the petitioner had also referred to.
Respond number 5.
Yes, Your Lordship.
Who is respond number 5? Commissioner.
Yes. Detaining authority. Yes.
Page number
14, annexure 1. This letter, may I read, Your Lordship? In pursuance of Section 10 of the NSA Act 1980, case of the person mentioned below, detained under the National Security Act, is hereby referred to the NSA Advisory Board, constituted under Section 9 of the said Act, Your Lordship. And this is on 21st April. That is within the 3 weeks window, Your Lordship. So, Your Lordship, I believe that a subjective satisfaction has been made out, Your Lordship, in order to prevent any future, not to take any chances of the detainee being released on bail. Because there's no guarantee that he would not be released on bail itself, Your Lordship. So I believe that will cover the grounds that the petitioner has taken, Your Lordship. If any queries, I have the records on.
That's all. Yes, any reply?
Yes, my lord. Now it is clear from the submission of the learned government advocate that there is a prima facie case against me. And now the condition under section 43D subclause 5 of the UAP Act, that if there is a prima facie case against me, it's impossible for me to get bail. So it satisfies. So there is no subjective satisfaction on the part of the detaining authority to detain me, because I'm not likely to be released on bail anytime soon. Since there is a prima facie case against me, the strict condition given under section 43D subclause 5 of the UAP Act states that if there is a prima facie case against me, I cannot be released on bail. So there is no subjective satisfaction on the part of the detaining authority to detain me, as I'm not likely to be released on bail, my lord. This is my humble submission, my lord.
Main contention.
Yes.
Yes. Art, Mr.
Yes, Sophie, my lord.
Yes. Yes, Sophie, learned counsel for the petitioner and Mr.
M. Longkumar, government advocate.
M. Longkumar, government advocate for the state respondents, and Mr.
Z.N. Moli,
Z.N. Muli,
CGC.
learned CDC.
Respondent number 2.
Anything you want to submit, Mr. Muli?
Yes, my lord, as long as we have received the representations submitted by the letter nail submitted by the detainee, we have acted upon the representations, and we at this count of the several other sections or another sections, so that there may be a bit late, but on that time there is some intervening period. That is a holiday that one is Saturday, 10 is Saturday, and 19 is Sunday, so that it will not come out on time. And that after examining all the representations of the detainee, there is no material cause or grounds to interfere with the representations of the detainee, so that the representation of the detainee was rejected on 28th of April 2026, and that the representation is endorsed to the jail superintendent and received and acknowledged by the detainees. That one is my submission.
Okay. Parties have made their respective submissions, order to be passed separately. Okay.
Yes, my lord. From supplementary courses, item number 56.
Number 56.
Lordship, in pursuant to order dated 13/5/26, service upon respondent number 2 has been affected through our office, PP office. We have sent it only on 9, so it's still awaited 9 of this month. So some time may be granted.
Conviction under?
Yeah.
Section 4, Section 6.
Yes, sir.
Mr.
K. Angami.
K. Angami, learned public prosecutor,
Yes, Lordship.
submits that he may be granted some more time to inform the court about the status of notice being served to the respondent number 2. When do you want it?
Lordship, after 4 weeks, instead of coming again and again. Since we just sent it only last week, Lordship.
In view of above? Yes. Anything? In view of above, list again. After 4 weeks, on a date to be fixed by the registry.
For orders, item numbers 57 to 65.
Yes.
My pleasure, your lordship. This instant IA is for deletion of name. Respondent number
Respondent
9.
number
9.
9. Why?
As she had resigned from the post of contract assistant professor.
Okay, so the entire thing has been listed only for this,
Yes.
for deletion of name.
Yes.
Any objection? Your good name?
Zuchamo.
Sorry?
Zuchamo.
Heard Mr. Zusamo, Waikiko, learned counsel for the applicant, who submits that the applicant, by filing this application, seeks the deletion of the name of respondent number 9 in writ appeal number. No, in writ appeal.
Number 52.
In writ appeal number 52 of 2025. Due to the fact that the said respondent has already resigned from the post concerned. Stop. Therefore, the applicants do not seek any relief against the respondent number 9 And his continuation as respondent number 9 is not necessary. Ms. V. Shukrel, an additional AG, appealing for the state respondents, submits that she has no objection if the application is allowed as paid for. In view of above, the name of respondent number 9 is allowed to be deleted from the writ appeal concern. From the writ appeal number 52 of 2025. Highest and disposed of as allowed. Then writ appeal number 52, you write, in view of the order passed today in IAC number 130 of 2026. What is to be done? Should it be replaced or the registry will just delete it?
Stop on. New cost.
I pray to file an amended cost title.
Okay. The appellant shall file an amended cost title in 2 sets before the registry within 2 days, within 1 week.
1 week, yes.
Within 1 week. Anything else to be passed in the writ appeal?
No, your lordship.
List again when?
Last week, it was to be listed after 3 weeks. This order came up last week also, these cases.
Last week?
Yes. Some of the private respondents are yet to enter appearance.
Okay. List the matter again in terms of the order dated 10/6/2026.
Much obliged.
Item number.
Please, Your Lordship.
Yes.
As directed by this honorable court, by order dated 13/5/2026, the state respondents have constituted the state sentence review board, and thereafter the
decisions taken.
My lord.
What is the decision?
It's for remission. It was for remission.
Yes, ma'am.
It's called here sentence
to release.
Sentence review.
Yes, Lord.
Sentence review.
I've served for more than 20 years, Lordships.
Hmm?
I've served for more than 20 years.
Life.
Yes.
Meeting was held on 10th of this month. And the
What
matter
is
is
the- what
put up
is
for
the-
final approval.
What was the decision?
My lord, as per the letter, it is stated that competent authority for consideration and approval. It is sent up for approval.
Approval of what? Rejection or approval of?
My lord.
Permission to remission?
Most probably for consideration.
We have to speculate now what has happened. We don't know what is what. They could have easily said that he was recommended for revision, but it has been sent to the competent authority for necessary action.
My lord, I'm communicated with these letters.
We can list it next week, Lordship. In the meantime, the additional AG can bring a record the outcome of the review board, Lordship.
10 June, isn't it? 10 June was just last
My
week.
lord, may I pray that this matter may be listed after vacation? By which time
You can update.
the outcome may
Next
be
week,
brought to the notice of
this
information.
can be.
Since a decision already taken, Lordship, it can be listed next week. And
yes.
And as you know, the opinion of the convicting court has to be also taken. Last court. So I'm sure, I believe that has been
My
done.
lords, may I pray that 2 weeks time may be granted.
That has to be taken.
Yes,
Opinion. In terms of Supreme Court decision.
2 weeks will take us back to after the vacation.
Yes, my lords.
What is to be done?
That witness.
15.
Do all the formalities in the meantime.
You're Mr. L.T. Sankam.
Yes, my lords.
Mr. L.T. Santam, Learned
Additional AG.
Advocate General, submits that as per the instructions received by him, the State Sentence Review Board
Was
held its
constituted.
meeting on 10/6/2026 to consider the premature release of the petitioner
Lordship.
Yes, my lord.
and the resolution taken by the review board has been sent to the competent authority for consideration and approval. In support of his submission, the learned additional AG has produced communication dated 12/6/2026, written to him by the Under Secretary to the Government of Nagaland, Home Department. Considering the same, that the matter be listed again on 15th of July 2026, by which time the learned additional AG shall inform the court whether what decision has been taken by the State Sentence Review Board as well as the competent authority to consider these resolution of the said board. Mr. Muajamir, Learned Counsel, appears for the petitioner. Give you.
Lordship, simplify, we are allowed to mention item number 48, Lordship. For hearing law.
48.
Lordship, since the matter is listed fixed at 2 p.m. If this matter can be taken up some other time, Lordship.
48.
Yes, Lordship, 48. It appears like there's a long list or this matter may not reach, Lordship.
When do you want it? On the prayer of Mr. Muajamir, Learned Counsel for the appellant. Matter stands adjourned to be listed again. After vacation.
Lordship.
After the ensuing summer vacation.
Obliged, Lordship.
My pleasure, Lordships. Lordship, if I may be allowed to mention item 21, Lordship, hearing item 21. I pray Lordships may be gracious if this matter may be listed after vacation, Lordship.
Okay, your good name?
V. Goza, Lordship.
On the prayer of Mr. So-and-so, Learned Counsel appearing on behalf of Mr. Azo, Learned Senior Counsel, who represents the appellants, not opposed to by the other side. The matter stands adjourned to be listed again after the ensuing summer vacation.
Much obliged. My pleasure, Lordship. Lordship, if you may be allowed to make a mention, my lord. Item number 2. 2? Yes, my lord. Here I have instruction to appear for respondent number 2, 4, and 5, my lord. So if 3 weeks time may be granted, my lord. You find my backlog.
2, 4, and 5.
4 and 5, my lord.
What is your name?
Metovero.
CGC is also there?
Yes, my lord.
Why last chance was given on the first date, sir? It was listed only once earlier.
Yes, ma'am.
And court said that last chance to CGC. Okay, Mr. Metevero, Learned Counsel submits that he has instructions to appear on behalf of respondent numbers 2, 4, and 5 and prays for a week's time.
2 weeks time, my lord.
To file his power.
My lord.
1 week for power? Then what else?
Lordship, if required, affidavit in opposition, my lord.
In writ appeal?
Yes, my lord.
Normally, you don't file an affidavit in opposition in writ appeal.
Not necessary. It's on the basis of records. You can submit a written argument if you want.
My lord.
Concise.
Prayers allowed. Please the matter after the ensuing summer vacation.
My lord.
All right.
Obliged, my lord.
So we'll rise then, come back at 2. Some hearing matters.
May I please your lordships? Lordships, hearing item number 45 might not reach lordship. So,
So,
can you let's it some other date, your lordship?
okay, fine. Mr. Mosu is there also?
Yes, Lordship. I'm for the.
NHM?
No, Lordship. This is a service matter, Lordship. It's a third party appeal.
Service matter, okay.
Lordship.
When do you want it then?
Next week, Lordship.
Lordship, next week, my Lord Justice, Your Honor, won't be able to take it up, lordship.
Single bench.
Single bench, yes. Just one.
So after the vacation then?
After vacation, Lordship, yes.
On the prayer of Ms. Esther, Learned Counsel for the appellant. Opposed to by Mr. N. Mosby, Learned Counsel for respondent number 5. Please, the matter stands adjourned to be listed again after the ensuing summer vacation.
Obliged, Lordship.
Interim may be extended, man.
Interim order passed earlier shall continue to the next date of listing.
Much obliged.
Obliged, Lordship.
May it please your lordships, I beg to mention item number 50.
50.
Yes, lordship. Since it's like not likely to reach, kindly list this after
All of
vacation.
you are giving chance to Mr. Chamir to have his time. That's paid for by Miss
Ubang Nanla Longchar.
Bang Nenla
Yes.
Longchar, Learned Counsel for the appellant. They are not opposed.
I've taken consent from the
And
government.
as consented to by the learned government advocate appearing for the state. Matter stands adjourned to be listed again after the ensuing summer vacation.
Obliged, lordships.
So the road is clear now. Hmm?
May it please lordship.
Mr. Zhou,
My lord,
yes.
55 is for motion only. So.
Oh.
Yes.
Motion?
Admission 55 is only to move the appeal.
Okay, yes.
So I have taken special permission from my senior CT.
Yes, what is this matter?
My lord, the petitioner appellants have preferred this read appeal, praying for setting aside the order judgment passed by the learned single judge on 26/5/26. My lord, petitioners appellant, they are the employees, officers of the employment wing, and the private respondent number 5 is from training wing under the same directorate.
Where is the judgment?
My lord, page 225.
Normally, the judgment should be in the first.
My lord. Correct, lord.
System has changed now.
Correct.
No. 225.
Yes.
This was your writ petition?
Yes, ma'am.
It was dismissed?
Yes, dismissed.
What was your case?
My lord, the case is this. Under the same directorate
of
employment and craftsmen. Employment and craftsmen training, skill development. There is a rule. Service rule is there 1998. So our services governed by the rules. Under the rules, particularly Schedule 1A, the strength of the employment wings are mentioned.
Okay.
Then under Schedule 1B, the total strength of training wings are mentioned. There under Section 1, Schedule 1A, for employment wing, the general promotion is up to director. Whereas for the training, because for the trainees, for them, the post mentioned under Schedule 1B is only up to deputy director. So against this rule 1998, the private respondent number 5 in the present case, along with all other staff of the training wing, file writ petition challenging the rules, legality and validity of the rules before the Supreme Court, before division bench. Then that was argued, and then division bench held that rule is valid. So petition filed by the private respondent 5 was dismissed. Thereafter, another gentleman, Engineer Wati Kewati, who was also from training wing, was given promotion to the rank of joint director, which was from employment wing. So that was challenged before this High Court under by filing a writ petition under 226 in the nature of quo warranto. Then when the writ petition was pending before this court, the respondent for Engineer Kewati, who was from training wing, resigned and he left. Therefore, my petition became infructuous. Now against the vacancy, resultant vacancy of Engineer Wati, who was from training wing, has been given to the present respondent number 5.
Another from another training wing.
Yes.
He also from a training wing.
Yes, my lord. I had to, so now at least unfortunately.
So you filed the writ petition.
Yes.
But it was dismissed.
Dismissed by the letters. Now the finding of the letter single judge is starting from paragraph 36. Now in that, unfortunately in this case.
The judgment of the division bench.
No.
Upholding the recruitment rules.
Yes. That is upheld.
This is WPC 261.
Correct.
Justice.
Yes.
Justice Sema and Justice Kadak.
Yes, that was division bench.
It was upheld.
So now, now the letter single judge in this present appeal is that held that the judgment of the division bench has no binding before the letter single judge. That is one consideration.
Obiter.
Yes, obiter. Secondly, unfortunately in this case, my argument that Engineer Kewati was promoted against the vacancy, result vacancy arose from employment wing was not considered. Then when we filed writ petition in the nature of quo warranto, Wati resigned and left. Against that, the present private respondent was promoted. So we challenged in this present writ petition. So that was dismissed. Now that finding was not given by the land single judge, unfortunately, before the writ court. So that's why we have come before the Supreme Court. The vacant post is meant for the employment wing. How can this be given to private respondent number 5? He was the private number 5 in the writ proceeding also, and in the appeal also he is the private number 5. That much only.
What is the other wing?
Training wing.
You are from employment.
Employment wing. So, my lord, as I have said now, in short, on the Schedule 1A, for the employment wing, there are 3 posts of deputy director, joint director, director. But for the training wing, on the Schedule 1B, there are last promotion as deputy director. So therefore, that was agitated by the training wing before the division bench, challenging the rules that they have been discriminated, they have been deprived from getting further promotion beyond deputy director.
Where's the decision?
That was dismissed and the rule was upheld.
Where's the decision of the division bench?
Yes, madam. Page. Lordship, start. Page, relevant pages 112. In this appeal, running page 112. 107.
It's a very lengthy judgment.
Lengthy judgment. Because the whole rule was discussed, and then finally the division bench has come to a conclusion that the rule is not violative of the constitutional scheme. So now let a single judge that has no binding. Like I said, my lord, my argument before the learner single judge was the vacancy arose from employment wing.
Yes.
Lordship permit, I'll just show 2 documents only.
You are from employment.
Employment wing. You can see.
The other wing is?
Training wing, madam. What you look up? Page? 1. No.
Can you show the rule?
It's annex, my lord. Page 139, my lord. Relevant page. Schedule 1A. Schedule 1A is for employment wing. Page 139, running page.
It starts from which page?
127.
Name of the rules is?
Nagaland Employment and Craftsman Training Service and Nagaland Subordinate Employment and Craftsman Training Service Rules 1998.
It starts from page?
Page 127. Then relevant pages, just for the time being, 139. This was challenged, but Division Bench has upheld this one.
This is Schedule 1A.
Schedule 1A, this is in respect of employment win, my lord. So this is the total strength for employment win, my lord. Under this, there are the last promotional post is director, general director, deputy director 3.
What is the lowest post?
The lowest post is employment officer for the class 2 gazette, my lord. Employment officer, starting from employment class 2 gazette, starting the entry point.
Entry point.
Yes, my lord.
Then regarding the other wing?
My lord, next page.
Training?
Yes, I'm coming to page 140. The entry point is vice principal because they are for the purposely for teaching the trade, yes, trade instructor.
They go up to the deputy director only.
Deputy director as per the scheme.
And they have challenged these rules. The schedule was not successful.
Not successful.
Okay.
So therefore, rule is settled as per the division, unless that is challenged before the Supreme Court.
So appointment of the private respondent number 5.
Yes.
Is against the rules.
Yes.
And your challenge otherwise was rejected.
Yes. But I'll just show one document.
Yes.
Lordship will see.
What is the reasoning given by the learned single judge?
Lordship.
This point.
Starting from paragraph
36.
36, 36, 36, 37, 39. These are the I mean, what you this promotion? What huh?
You have invoked the writ of quo warranto.
Yes, my lord. Because this is a clear case of transposition, usurper, without any sanction authority of law. Because from the training wing, a person cannot come and fill up the vacant post of employment wing, because there are 2 separate channel of promotion, 2 separate seniority lists, entry point is different, even qualifications are different. And unless the rule is amended or unless the rule is quashed, the rule will remain. That's why, how do we put a supplement?
Lordship, I'm here for the private respondent. The fact remains, Lordship, under Rule 3, Lordship, of this rules of 1998. Lordship, may kindly come to page 130.
How do we put the reason?
The submission given by my learned friend is in contradiction to the service rule, Lordship. Lordship, may kindly come to page 130. Now the learned single judge has taken consideration of this rule also. Rule 3, 130. Lordship, there are 2 different ways. We are not denying that fact. Lordship, may kindly see the left hand side.
Yes.
Craftsman wing. That is training.
Left hand side of 130.
Page 130, Lordship. Sorry, right hand side, sir, Lordship. Right.
Okay, craftsman
training. Yes. The post of joint director is there. Then the convergence is in the post of director. So this aspect of the matter was taken in consideration by the learned single judge.
Craftsman Training Wing.
Joint Director. Now, Lordship, come to Schedule 2B now. Schedule 2B, page 143. Schedule 2B. Lordship has found.
2B, yes.
Lordship, Joint Director. This is training wing. So I'm not occupying a post which is not meant to be.
That's why I want to show.
Held by me, Lordship. So it's only the Joint Director post. Now that has been taken care of by paragraph.
What is
38, page 246, the judgment, Lordship.
But then why is this Schedule 1A and 1B?
Schedule 1A is the strength of the cadres of the employment.
No, under Rule 4. Rule 4.
Rule 4 is the total strength for the service.
Lordship, may kindly come to Rule 4. Page.
Schedule 1A provides the top post as director.
Yes.
1B provides as deputy director. Only.
Yes, Lordship.
Why is that? While Schedule 2B provides for joint director again.
So there was a disparity, Lordship. No, that has been taken care by paragraph 38. Now, under Rule 4.
That's right.
Rule 4 and Rule 5, what are they? Let's see.
Lordship,
Strength of
strength of service, yes.
Method of recruitment.
Yes. Rule 4 is the strength of service, Lordship. The number of posts, permanent as well as temporary, each under each wing and category, shall such as may be determined by the government from time to time. So the powers with the government, Lordship. Now there has been a notification in 2015, which was never challenged by these petitioners.
No, one thing, Schedule 1A.
Lordship.
Yes.
Where does it say it's only meant for employment and not for training? Mr. Zoe?
My lord.
Schedule 1A.
Yes.
Top post is director.
Yes.
Does it provide anywhere that it should be from the employment only, not from training?
Yes.
It is, my lord, the promotional channel starting from employment officer up to director. Schedule 1A is the total strength for the employment wing, my lord. Schedule 1B, read with Rule 4, is the total strength of the training wing. And the entry point for the training wing is vice principal, only one deputy director as part of it. And this, like, when this rule was put to challenge before the division bench, now division bench has upheld that, this there's no illegality, there's no unconstitutional infirmity as far as the rule is
The
concerned.
director can be from either of the streams.
Yes.
The director.
Either stream, as per Rule 3.
Or only this, because each of the wing has a joint director.
Yes.
Yes.
So your point is that respective joint director of each wing has to be held by an employee of that wing only.
Yes.
But we are not on the director. We are on the dispute
We are-
over joint director.
And my lordship will appreciate, as in this case, the rule has been already settled by division bench. Our only concern now is whether the promotion of previous number 5
Violates the rules
violates the rules.
or in conformity with the rules.
Yes. Whether the promotion of previous number 5, the vacancy held by previous number 5 is meant for the employment or training wing, that much only. Because rule has been already discarded, the challenge put under challenge, and then that was already upheld.
What do you say about this page 143, Schedule 2B?
That is Schedule 2B page.
They rise up to the post of joint director.
Yes.
My lord, that was the argument before the division bench. Detail with was discussed. Now that Schedule 2B relates to training wing. Now provision is made, but in the strength, Schedule 1A. Schedule 1A is the strength, and this is the mode of promotion. If government create post for joint director, if government create post for additional director, then in case this is the mode of promotion, this is the mode of recruitment. That is the method. Now the main concern is strength. Unless there is strength in the cadre, department cannot give promotion to anybody. So the strength is as Schedule 1A and Schedule 1B. This Schedule 1B, Schedule 2B, Schedule 1, Schedule 2A is mode of promotion, mode of appointment. So therefore, for as far as the training wing is concerned, only when government created post for the post of joint director, as on today, in terms of the rules, there's only one post of deputy director for training wing. Forget about joint director. If we go by Schedule 1B, total strength of the training wings. The post of joint director in respect of training wing has not been created. There is no post creation
of joint director
in respect of training wing. So now therefore the post held by the private respondent number 5 is the post meant for the employment.
Yeah, that is your primary.
That is the primary contention, my lord.
As far as the joint director post is concerned, Lordship, it has already been notified in 2015. Lordship, it's
for the training wing.
Yes, and which has not been challenged by the writ petitioners in the writ petition.
Notified means?
Lordship,
Post created?
Yes.
Where is that?
Upgraded. For one deputy director post was upgraded to joint director.
Where is that?
Lordship, I'll show. Lordship, may kindly come to.
I'll read out. Every decision.
It's in my Lordship.
My lord, running page 179 in the read appeal.
171.
179.
Thank you. Clear, no. No.
179. Running page 179. Read appeal. We have a name. Yes, here.
No, 171 is different.
179. 179.
Yes, 179. Lordship. 16 January 2015.
Now, whether there is any distinction drawn here that it is upgradations from employment or it has been.
Lordship, may kindly see the training, the content of the notification, Lordship. The content of the notification.
To look after by the craftsmen's and training wing.
Yes.
Under the same directorate.
From the employment, we have to look after the training wing. I'll show. I have the.
They are saying that I cannot hold the post, but they are coming and holding my post. if they say so, Lordship.
No, craftsmen's is another wing.
Yes, it's a different wing.
Training
wing. Craftsmen and training wing, they're one.
Craftsmen's comes under training.
Employment is one wing, Lordship. Craftsmen and training is another wing.
Okay.
So, Lordship, the last line of the first paragraph, the newly upgraded post of joint director who holds the post shall look after the craftsmen and training wing under the same directorate. So this was never challenged by the writ petitioners.
This is the post you're holding?
Yes.
Joint director?
Yes.
Craftsmen's and training?
Yes.
When according to the petitioner?
Absolutely. My lord, that is absolutely wrong. This is the area where learned single judge has not considered. That's what I'm saying.
No.
Now, Lordship, I'll just
dealt with.
Let me just finish. I'll read it out. My lord, this notification was issued. I'll read out. Dated 16 January 15. The governor of Nagaland is pleased to upgrade one post of deputy director out of the existing three. Three belongs to the employment wing. 3 deputy director as per Schedule 1A. In deputy director, as per Schedule 1A, we have 3 deputy director. For the training, only 1 deputy director who is still present.
But the last line of the first paragraph gives it to the craftsmen and training.
My lord, then I'll read. I'll finish that. deputy director out of existing three posts of deputy director to that of joint director class 1 gazette in the pay scale so and so with grade so and so per month and all other allowance as admissible from time to time under the director employment craftsman training Nagaland Kohima and promote Alan Kumar, the senior most deputy director to the newly upgraded post of joint director. Alan Kumar is from employment wing. He's still there. Employment wing. The newly upgraded post of joint director who holds the post shall look after the craftsman training wing under the same directorate. Two is relevant. These issues with clearance of PNR, department so and so, finance, and then last sentence, my lord. Also, the approval cabinet decision right number so and so that is 18/12/2014. Now I'll show the cabinet decision. Cabinet decision is clear that it is from employment wing. My lord, I may be permitted to show the cabinet decision here. By which I can give you a copy.
No, Lordship, this is not a part of the report.
No. I'll just show. See, because this has referred to cabinet decision. This notification referred to 18/12/2014 cabinet decision. My lord, this is on the top. 18/12/2014 office memorandum. Now agenda 7, upgradation of one post of deputy director to that of the joint director employment. My learned friend has not read this. Cabinet approved the proposal of so cabinet approved one post of deputy director out of 3 from employment. The word of employment. This is the cabinet decision. So arising out of this cabinet decision, this 2015 memorandum is notice was issued. There is no doubt. My only submission before this, as I have said, learned single judge has not considered my argument. Only one aspect that in writ proceeding, I said petition number 5, provision number 5 was given promotion against Engineer Wati, against whom we filed writ petition. So he resigned, he left because he was holding our post. After resigning from service, we withdrew our writ petition become infractions.
There was no decision on that.
Yes, that was not recorded. That is my grievance. That at least in the finding, whether my submission is wrong or right, that should be recorded, and there should be a finding. That was the whole case in the writ petition, my lord. My whole case in the writ petition was that Provision number 5 was promoted against the vacant post of Engineer Wati, who resigned and left because we challenged his promotion in the writ court in the nature of co-warrantor. He resigned, he left. So after that, we make a representative department that these vacancies should be filled up by us, employment wing. Instead of doing that, private respondent was promoted to the post of joint director against Engineer Wati.
Jumping the stream.
Yes, that's what I said. Transposition. Supreme Court banned that transposition. At the time, I'll show the transposition judgment.
Have you challenged this notification of 16/1/2015?
No. I should not challenge. Because this is from our wing. I should not challenge. Because cabinet decision very clear shows.
See, Mr. Zoe.
My lord.
Thing is that as per your submission.
Yes.
The total number of joint deputy director.
Yes.
From the employment side
yes.
is 3 posts.
3 posts.
3 posts.
As per rules.
And from the training, there's only 1.
Only 1.
Now, which one has been upgraded? 1 post from the employment.
Correct.
Has been upgraded.
Correct. And given to our cadreman.
And given to craftsmen and training.
No. Given to alamis from our wing.
No. You read this notification. The newly upgraded post of joint director who holds the post shall look after the craftsmen and training wing under the same directorate.
That is the truth. Not give out to look after because there is no joint director post from them. I have to look after. Vacancy cannot be given to them. I have to look after because for them in terms of rules, only deputy director is there.
Employment wing did it have joint director earlier? No.
Yeah, earlier.
It had.
Yes.
So now 1 more post is upgraded.
Yes. Joint director, there's already 1 for the employment.
Employment.
Yes.
But the training does not have.
Does not.
Only
because
1.
There's no sanction post. No sanction post.
So 1 post of the Deputy Director was upgraded to the post of Joint Director.
Yes.
And while remaining under the employment side, it looks after the training.
Yes.
This is
So that
what
you
you
show me
say.
the promotion of
There'll be two joint directors.
promotion of a private smart. I have flag.
There'll be two joint directors for the employment now.
Yes.
One
No,
is looking after employment, one is looking after training. So it is not that somebody from training should come and get promoted in the employment side. This is what you say. You cannot mix up.
Madam.
Training is training,
Yes.
employment is employment.
Cannot. Two separate general promotion. Entry point is different. Then the service rules very clear that they have their promotional post for the training wings only up to deputy director as per the strength of the cadres in terms of Schedule 1A and Schedule 1B. Where is the promotion of that fellow? 1-1? I want to show. My lord, just for a moment.
Director of this. Just wait.
Yes, Abi. Itu what is in there?
There was one person sent director for employment. None for training, only the only one.
No.
Now this is one post of the out of the existing. Which are two. No. Wait, it's three deputy directors. There's three posts for the employment.
Give one.
That has been
Even
taken.
is the copy.
And we upgraded as joint director.
Correct.
That joint director of employment will look after the craftsmen and training wing.
Good.
So this still extends.
Good.
Look after the craftsmen.
Correct. That's what we got it like that.
That's not very logical. So they did not have a joint director post. The streams are slightly different. According to the.
My lord, one clarification. I want to give, lordship may kindly come to page 118. I just want, because his promotion was not arising out of 2015 memorandum notification. No. Lordship may kindly come to running page 118.
What is that?
How he was promoted. Promotion order of provision number 5. May I read it out?
What's his name?
Engineer H. Alongse.
Okay.
Training wing, belongs written training wing. From deputy director to joint director in level 6 so name Engineer H. Alongse against the resultant retirement vacancy of Engineer Gauhati. This is his promotion was not in terms of notification 2015. That was the whole thing that it went wrong before the land single court. Leonard single judge had failed to appreciate and give any finding on this. My whole argument before the court was that his promotion was against Engineer Gauhati. Gauhati was given promotion against the resultant vacancy of employment wing. Therefore, we filed writ petition in the nature of quo warranto. So he resigned and he left. Now his promotion, Alonso's promotion has nothing to do with notification 2015. Has nothing to do, this is the wrong interpretations of before the landed single judge, my lord. That is my whole case. My argument before landed single court was, all along, this post was held by employment officers, not by the training wing. So now the promotion of private number 5 clearly mentioned that the promotion was vice retirement of Gauhati.
Gauhati retired or?
Resigned and left. We filed writ petition against him.
He resigned.
When the writ petition was filed against him in the form of quo warranto, he resigned, he left. So against this, we make represent the government. Now, since what he resigned and left, give us.
What was that writ petition? Have you annexed the order?
We have.
Is it annexed to this writ appeal?
Order is not annexed. I have stated here, but not annexed.
Okay, where have you stated that? Show us.
My lord.
Show us.
Writ petition, writ petition. Writ petition there. That was the whole case before the read court. Engineer Gauhati. My lord, page 40, my read petition against my read petition. Page 40, running page 40, page 40, relevant page 40. Last paragraph, my lord. It is pertinent to mention herein that some of the employees from the employment wing, including petitioner number 1, has also earlier filed a co-warranto petition number as WPC number 170 of 22, challenging the appointment of the promotion engineer Gauhati to the post of joint director, as the said post held by him was a resultant vacancy caused by Sri M. Lewan Konyak, who was from the employment wing. The said read petition was withdrawn as engineer Gauhati, who was the private respondent, resigned from his service during the pendency of the said read petition.
When was it withdrawn?
What is it?
Whose writ petition is this?
It's my read petition. Employment wing challenged engineer Gauhati's promotion because he has jumped from training wing to employment wing.
Okay.
Yes.
You were not the only one to challenge. There were a group of people.
All the employees from the employment wing.
Okay.
Even in that case, employees from the training wing.
See, do you have the copy of the date on which it was withdrawn?
Yes.
Tell us that. So on this note, we'll admit the writ petition, writ appeal.
No, nothing.
And we'll pose the matter for.
My lord, the date 22/1/2024.
22/1/24. Withdrawn, no?
Yes, withdrawn. Our representation was withdrawn because he resigned.
Withdrawn.
Since we've challenged his promotion.
Withdrawn or infructuous?
Resigned as infructuous.
Infructuous.
Yes.
He resigned because he resigned to contest election.
That I don't know.
Not out of the fear of the writ petition.
No, it's okay. Whatever it may be, because of he would no longer be there.
Yes.
The matter ended like that.
Yes. Because
but there was no decision.
No
decision to that.
Because
now that issue has been dealt in the present impugned judgment. And paragraph number 48.
Therefore,
that has been taken care of.
Before the read court, my whole argument was this private respondent along say cannot be given promotion in place of Wati because we challenged his promotion and he resigned, he left. So this should go to employment wing. That was my whole argument before
that has been taken.
For that, the learned single judge has not given any reasons or finding.
Okay.
This is my grievance.
So the reason and finding is
examine. At this stage, we can't say much also.
Lordship.
We'll examine on that note, we'll admit the appeal and post it for hearing.
Yes.
After the ensuing.
That was the unfortunate part. My argument was not given any finding or no record.
No. That is paragraph 38 speaks about his submissions and that has been taken care of in paragraph 38.
Submission was record, but in the finding, nothing, not a single word was uttered. How learned single judge had come to the conclusion that petition should be dismissed?
It has been determined, analyzed as determined.
Okay.
Paragraph 245.
Please write. Heard Mr. Azo, learned senior counsel, assisted by
Takakichu.
Mr. Takakichu, learned counsel for the appellant, who submits that being aggrieved with the judgment and order dated 26/5/2026.
Yes, ma'am.
Rendered by the learned single judge in WPC number 294 of 2024.
Yes, ma'am.
Dismissing the writ petition of the appellant. The present writ appeal has been filed. Of the learned counsel submits that as per the Nagaland Employment and Craftsmen Training Service and Nagaland Subordinate Employment and Craftsman Training Services Rules 1998.
Yes, madam.
Page 128. Okay, 128. More particularly under Schedule 1 bracket capital A corresponding to Rule 4 of the said rules, the highest post of that is director, that is the post of director, is a selection grade post, and it is to be filled up from
Employment.
the employment wing
Yes.
of the service. So, whereas as per Schedule 1 bracket capital B corresponding to Rule 4, the highest post insofar as the craftsman
Training
wing is concerned, the highest post is the deputy director post. Despite the same, after full stop, one officer, namely Engineer Gauhati, who belonged to the
Training wing.
Was promoted to the post of joint director in the employment wing against the vacancy caused by one Sri M.
Lewang
Konyak,
who was from employment wing.
who was from the employment wing. Stop. Aggrieved with the same, the number of employees, including the present appellant, initiated WPC number 170 of 2022, challenging the appointment of Engineer Gauhati to the post of joint director, since he was from the training wing. And not eligible to hold the post meant for an employee of the employment wing. Stop. However, during the pendency of the writ petition, Engineer Gauhati, who was arrayed as respondent number.
Respondent number.
Okay, don't write.
Okay.
Who was arrayed as one of the as the private respondent.
He was the lone respondent, my lord, private respondent. He was a private respondent.
He was arrayed as the private respondent, resigned from the post, and therefore the writ petition was disposed of as infructuous by order dated 22/1/2024.
My lord,
After
he resigned on.
thereafter, the present respondent number
5,
that is Engineer H.
Alonse,
was appointed to the post of joint director
in the vacancy of Wati, my lord.
in the vacancy created by Engineer Gauhati.
Yes, my lord.
But here it is shown that he retired.
Yes, he resigned. He resigned.
Stop aggrieved. The appellant filed writ petition, WPC number. How many of you are there? More than one.
More than one.
Aggrieved. An appellant is only one now.
No, one. We have
Appellants.
altogether 11.
The appellants.
11.
Read petitions.
Okay. Appellants, file WPC number 294 of 2024.
Yes, ma'am.
Challenging his appointment. But the learned single judge by judgment and order dated 26/5/2026 found the writ petition to be without merit and dismissed the same. Stop. Aggrieved, the appellants are before this court through the instant writ appeal. Stop. The learned senior counsel submits that by the impugned judgment and order, it can be seen that the learned single judge has failed to consider the fact that respondent number 5 was appointed against the vacancy caused by engineer Gauhati,
Yes, my lord.
who in fact was from the training wing. The rules, the service rules do not provide for such kind of promotion, interrelated promotion from the training wing to the employment wing.
Yes, ma'am.
Stop. In fact, a challenge was made to the service rules through WPC number 261 of 2021 and the division bench white order dated 29/2023 did not find merit in the writ petition and dismissed the writ petition by upholding the provisions of the service rules. Stop. The learned senior counsel therefore submits that the impugned judgment and order of the learned senior judge should be interfered with by this court. Next para, considering the above projection, a proper consideration of the entire matter requires to be done, and for which let the appeal be admitted. Issue notice to the respondents.
We have already served notice to all of
3
them.
weeks. Mr.
I'm for respondent number 5.
My lord, I'm delivering for respondent number 1, 2, 4, 3, and 4.
Mr. E. Deepak, learned government advocate, accepts notice on behalf of respondents numbers 1 to 4, while Mr.
And Mozu.
N. Mozu, learned counsel, accepts notice on behalf of respondent number 5.
Lordship.
Notice is therefore complete. Extra copies of the writ appeal be furnished to the learned counsels appearing for the respondents today, if not already done. Release the matter for hearing
Yes, my lord.
after the ensuing summer vacation. You want a date?
My lord, I have an interim prayer also. By issuing interim prayer, it will not cause prejudice to him because before the writ proceeding, his promotion was not stayed.
So what is the point of having an interim now? There was no stay order in the writ petition.
No stay order.
No, that's what.
I must be clear.
So I don't think there's any requirement of having an interim order.
No. 29 July for hearing.
Is it okay? 29 July? List for hearing on 29 July 2026 for hearing as agreed to by the parties.
I file a caveat. Caveat number 9 of 2026.
A caveat filed by the respondent number 5 gets is discharged.
Lordship.
Majole.
Cabinet. This also. One more.
Can be kept here.
For hearing, item numbers 51 and 52.
So Jamir,
Lordship.
what is your case?
This matter relates to recruitment to the post of constables, excise constables.
Okay.
In the excise department. Initially, only 40 posts were advertised, but by a subsequent corrigendum, 6 more posts were added. So total it comes to 46 posts. And about more than 10,000 candidates have applied for the post. Initially, the recruitment process was only confined to physical test and the oral test. And subsequently, by way of a corrigendum, by issuing proper publication in the newspaper and notice, written was included. The writ petitioners, about 14 in numbers, they have challenged the inclusion of the written test on the ground that the rules of the game cannot be changed after the commencement of the match. And to support that, they have relied in the Tij Prakash Pratap's case. But then by relying on that, the learned single judge has allowed the writ petition and then directed the department to go for a fresh recruitment. So against that, the present writ appeal has been filed. And then on the day of motion, that is on 3rd December last year, that is 2025, it came up before the Honorable Chief Justice. And after hearing to some extent, and also by examining the finding in the Tij Prakash Pratap's case, the Honorable Court was pleased to allow the department to go ahead with the selection process. However, the result should not be declared without the leave of this Honorable Court. So after completion of the recruitment process, we file an application IA for seeking the permission leave of this Honorable Court to declare the result. But then instead of considering that IA, let us hear the entire petition. I think that makes sense.
You are in, so you are in favor of the exams?
Yes.
You appeared for the exams? You
are the state is the appellant here. The state is the appellant here. If we accept the finding of the learned single judge to go for a fresh recruitment, then there will be a lot of complications in the sense that
who were the petitioners?
Petitioners were the present respondents.
Petitioners were successful in the challenge.
Yes.
Saying that you cannot change the rules of the game.
Is filing the appeal.
So learned single judge says that then the entire process set aside.
Yes.
Go for fresh recruitment.
Yes.
Now fresh recruitment has started.
No, it's
already included. No. The ongoing examination.
Earlier ongoing examination.
Yes. Okay. Has been allowed to proceed with.
To proceed, but no results should be.
Yes, no results will be declared.
Okay.
So brief background will be required, Lordship, to understand the case. Can we come to writ appeal, page 18? I'm starting from the advertisement because only few documents I'll rely. Because
you were the private respondents.
No, I'm the state, Lordship. The state.
Oh,
the writ petition was allowed, directing the state, directing the department to go for a fresh recruitment process. But the grounds of challenge are many. One important aspect is having participated in the selection process, having accepted the terms and conditions of the recruitment, having participated, they are again turning around and questioning the selection process. That is one of the grounds. Secondly,
they came to challenge after participating.
Yes.
Not before.
Yes, that is one. Secondly, the inclusion of written. According to the learned single judge as well as to the petitioners, rules of the game cannot be changed. And to support that, they have relied in the Tij Prakash Pratap's case, which was decided in 2025. However,
Constitutional bench.
yes, Tij Prakash Pratap's case says that changing up the rules, if it is not violative of Article 14 and 16, if there is no discrimination, arbitrary, then that can be allowed. So, without considering that aspect, the learned single judge has arrived to a conclusion, relying on one of the memorandum issued by the Commissioner of Excise, which was issued on 19/7/2016. Whereas this memorandum is not approved by the government, and this memorandum was not applied even in the examination which was conducted by the department in 2018 and in 2019. In other words, it has no approval of the government. Therefore, in the eye of law, it is nonist. But then by relying on that, when this notification of 19 July 2016 prescribed the manner how the exam is to be conducted, you have not followed this. By relying on that notification, memorandum, the writ petition was allowed. And we are agreed by that on the ground that, look, this has not been approved by the government, firstly. Secondly, it was not applied even in 2018 and 2019 examinations. Therefore, by relying on the government, which is not approved by the government, the finding has been arrived by the learned single judge. So kindly come to page 18.
Yes.
This is only to show the advertisement. It is on 7th April 2025, page 18, Annexure A. Initially, only 40 posts were advertised. And then here I will refer to only 2 paragraphs. That is paragraph 15 and 16 towards the bottom of the page, Lordship will find. Last 3 lines. 15. Any omission or commission will be rectified through the notification and addendums. That is one of the conditions. This I'm showing this, referring this because of the fact that the discretion has been given to the departmental recruitment board to make additional rectification. And then 16, in the event of any dispute or recruitment process, the decision of the departmental recruitment board, DRB, will be final and binding. And kindly come to the next page. This is the memorandum which I have been referring to, Lordship, page 19, Annexure P. This is on the top, it is shown as March. But then if we look at the next page, at page 20, it was issued on 19 July 2016. In the bottom of the page, Lordship will find. So it is 19/7/2016, and there is no dispute on this. So by relying on this memorandum, the learned single judge has rendered the ambiguous judgment and order dated 16/10/2025. And this memorandum has no approval of the government. And in 2018 and 2019, this memorandum has not been followed. But then this was brought by the writ petitioners at the time of filing the writ petition. And the entire basis of the case of the petitioner is based on this. This is how the learned single judge has also decided the case by relying on this. But my respectful submission on this point is that since it is lacking the approval of the government and it has never been followed, in 2018 as well as in 2019 examination was conducted, it was not applied. Therefore, it is nonist in the eye of law. Now kindly come to page 21, Annexure C. This is the minutes of discussion held on 16/9/2024 on the recruitment of the uniform services. Not only the Department of the Excise, but Police Department, and there are a few uniform services, which is given in the first paragraph. And we are confined to paragraph 1, 2, and 3. And both paragraph 1, decision applicable to uniform services. Each department shall set up the respective departmental recruitment board with representatives from the administrative department, PNER, finance, and law department. 2. All vacancies shall be advertised at least in 2 local papers and the respective department's website. This has been done. The DRV shall maintain transparency and fairness while carrying out the recruitment process. And then in paragraph 6, how many fees is to be charged? It is given, and it is 300 exam fee. So if we just roughly calculate 10,000 into 300 will come to 30 lakhs. So suppose if any fresh recruitment and it is cancelled, if all these 10,000 persons come and claim for their exam fee, then it will be a burden again. And again to conduct another examination consisting of more than 10,000 candidates. Lordship is well aware what is the expenses involved in examination process consisting of more than 10,000 candidates.
What is this CMRC full form?
This is the venue, I think. Common Minister CMRC.
Okay, venue.
Chief Minister's Residential Complex, I think.
Okay.
And by this notification, the departmental recruitment board was delegated the powers to conduct the examination, Lordship. All the uniform services and excise department is one.
So every department will have their own recruitment board?
Yes. But then the learned single judge arrived to a conclusion that, look, you do not have the power to change the conditions. But this is the approval to conduct the uniform services by the departmental recruitment board. So,
before that, we had seen that memorandum. You said which is not approved by the government.
Yes.
That memorandum provided for written test.
Yes. Many formalities have been prescribed there. Physical standards have been shown in what manner it has to be done.
Anything on written test?
No. Initial advertisement, there was no written test. I'll come to the relevant point now.
Later on, written test was introduced.
And next page, page 23, Annexure D. This is an exemption to conduct the examination by the Nagaland State Selection Board, because Lordships are aware that all the grade 4 posts can be now recruited by the Nagaland State Selection Board, NSSP in short. But then the uniform services were exempted from the review of this NSSP. And this is the circular.
This is the circular.
That is 19 September 2024. Exempting the uniform services. And excise is one, which is exempted.
Yes.
Now kindly come to page 24, Annexure E. This is 25th March 2025. This is the letter from the government. Subject approval for sitting of Departmental Recruitment Board. With reference to the subjects headed above, I am directed to convey the approval of the government for sitting of Departmental Recruitment Board to recruitment of 40 posts of excise constable. As I was mentioning, initially it was 40 and subsequently 6 posts were added. There is no dispute on that. So, and then recruitment board has been constituted. Here, Lordship will find, besides the Commissioner of Excise, representative of the pioneer, 1 member, representative of finance, representative of law and justice, member, representative of administrative department, assistant commissioner, establishment, member secretary. So this is the approval of the government to conduct the examination. And Lordship will find clearly. Now, the next page, Annexure F, page 25. This is a notification by which the district departmental recruitment board has been constituted as notified earlier. And this is one of the impugn order the petitioners have challenged, 23rd April 2025.
What is the difference?
The earlier one, 25th March, is allowing the department to set up departmental recruitment board. And then the second one is the constitution of the departmental recruitment board. And then page 26, Annexure G. This is addition of another 6 posts to the ongoing examination. And page 27, Annexure H. This is an RTI by the Dimapur Naga Students Union, in short, DNSU. And then they were requesting the department how and what manner examination is to be conducted, and then what is the percentage of marks, whether you have followed the Supreme Court order that written marks should be limited only to 12.5%. All these things were sought for in the, and then whether written test is also included. 3 RTIs have been received by the department. So in order to maintain the transparency, the department has taken a decision. The Department Recruitment Board has taken a decision to include written, because it was so difficult with so much of number of candidates to judge only from the physical test as well as oral. And in the meantime, RTIs were also received. So we thought it appropriate to include this written examination, and it was widely published, and it was more than 1.5 months in advance. And all the candidates were given equal opportunity to participate in written tests also. But they are agreed that inclusion of written tests without the approval of the government is illegal. But then the approval of the government is, the DRP has been approved by the government, and after obtaining approval from the government, advertisement was issued with clear terms and conditions. It was on the strength of the approval of the government, the DRP has issued the terms and conditions of advertisement. They have accepted that, and they have appeared in the exam. But after appearing in the exam in the midway, they turned around and then challenged. And the writ petition.
The results of that are awaited.
Yes, yes.
They are waiting to be cleared.
In the midst of the examination, they have filed, and then decision was given, but then we have filed writ appeal. And then in the writ appeal, permission was, department was allowed to go ahead with the selection process. Because by inclusion of written, nobody has been prejudiced. No discrimination. Equal opportunity was given to all.
That's true. But the only thing is that the taste prakash principle.
Yes,
we have to see.
yes, I will come to that later after I finish the facts.
I've forgotten.
I'm coming to the end of the facts now.
I've forgotten later. That was constitutional bench or
Yes,
just,
yes, Constitution bench, Lordship. And I'm relying on paragraph 51, 52, 54, and 56.
Where is the order by which you are allowed to continue with the
It is in the additional affidavit, IA. IA 68 of 2026. Page 10, Lordship will find.
Okay, the order is here only. This person is writ appeal only.
Yes, in the writ appeal.
3/12/2025.
May I read, Lordship? Page 12.
312.
It's a 3-page order only.
I don't think so. I think it's more than that.
The operative portion, I mean, Lordship.
No, that's okay. It's okay. You don't have to read everything. So I just wanted to know what was the order. That's all. See, the last part only.
Yes.
At this stage, Mr. Jamil has informed the court pursuant to the corrigendum, written tests have already been conducted. In that case, appropriate, we permit the state to continue with the recruitment process, but making the end result subject to the outcome.
Yes.
Shall not be declared with the leave of the court. So leave has not been sought. Results has not been declared till now.
Yes.
All right.
This is the
The
application.
process is completed.
Yes.
Okay.
Everything has been completed. And in the written, out of the 14 petitioners, 8 petitioners participated in written also. Even after filing the writ petition.
8 petitioners.
Yes.
Okay.
8 persons have participated even in the written.
Any observation to that effect?
No, Lordship.
Participation subject to without prejudice to the right to challenge, nothing like that.
No.
Now, total post is 46 posts, isn't it?
Correct, Lordship.
40 plus 6.
Yes.
Initially 40, then
Yes.
after 46.
Correct. Written result was declared on 19/1/2026. And medical test was conducted on 10/2/2026. And then result was declared, the entire interview was completed on 21/2/2026.
Written results are declared.
Yes.
Okay.
And then oral was also conducted. One of them qualified again, one of the petitioners. So result is awaited. We have completed all the process on 19/2/2026.
Written results is known to everybody.
Yes.
It's declared
It is
already.
enclosed.
Now, only if you pass the written, then you can go for the interview. Is it like?
Yes, medical test and interview.
Interview. So the results of the interview is not yet out.
Yes, it is awaited after hearing this, after the judgment of this case. So the last annexure, the last document which I am relying is annexure J.
Page 30.
Page 30. By which this is the notification for written examination.
After the corrigendum.
Yes. After the corrigendum. Writ petition was filed on 22/7/2025.
22/7.
2025.
Okay.
And then written test was held on 9/8/2025. And in that, 8 of the petitioners have appeared in written test after filing the writ petition. And then written result was declared on 19/1/2026. Medical test on 10/2/2026. Interview completed on 21/2/2026. Now I will come only to the grounds.
Mr. Jamil, just one more.
Lordship.
19/1/26. Medical examination.
Yes, a written result, 19/1/2026.
Written result.
Written result.
Written test result.
Yes.
Then
And then 10/2/2026 medical test.
10/2/2026.
Yes. And
Medical test.
interview completed on 21/2/2026. And the IA was filed seeking the leave of the Honorable Court to declare the result. But it was felt appropriate to hear the entire petition because once result is declared, the entire petition will be rendered infructuous. So that is quite reasonable to hear the matter once for all. So I will only now, I believe the facts are clear on that.
Yes.
2 contentions which the present respondents, they are contending is, even the learned single judge also arrived to a conclusion that even for inclusion of written, it should not have been done by the Departmental Recruitment Board, but it should have been done with the approval of the government. But on that point, the approval of the government constituting the Departmental Recruitment Board, what more approval do you need more than that? They have been given whole discretion. Everything was allowed, and terms and conditions of the advertisements were issued by the Departmental Recruitment Board, and they have seen with your own eyes and with your open eyes they have seen, and they have participated in the selection process. And now they are turning around and questioning the selection process. If it is not done in accordance with law, in the first place, without appearing in the exam, they could have challenged that, which they have not done, Lordships. So this is against the law laid down by the FX Court that having tried their luck, they cannot come and turn around and question the selection process. So there we are questioning the finding of the learned single judge. By participation in the selection process, the petitioners, they have surrendered their rights, which this entitles them for equitable relief, Lordships.
So in other words, the decision to take to introduce the written test, according to the petitioners and as per the learned single judge, was not done with the approval of the government.
Yes.
But you say that further approval is not required.
Yes.
The board has already been empowered
Yes.
to do the needful.
Yes. So that is very clear, Lordship. And inclusion of written. Going by the service role also, service role is vague. It is not clear that whether the recruitment of constables where written test should be there or not, role is silent in that. So in absence of any specific statutory provisions in the rules, then the board has the power to substantiate the provisions of the rule, provided that does not cause any prejudice to anybody. If it is not arbitrary, if it is not discriminatory, then that can be allowed. That is what Dish Prakash Patak says also.
Now, talking about recruitment rules, what is the recruitment rules?
Rule 5.
Is it?
I have placed the copy of the rules on the last occasion. I do not know whether it is still available in the files.
What is it called? Rule? Name of
Nagaland Excise Service Revised Rules 1999.
It's not here. 1999.
Yes. And recruitment is mentioned in Rule 5, under Rule 5. Lordship will find at page 3.
Recruitment to the service.
Up to the commencement of these rules shall be.
Who are the members of the service? It includes constables also.
Yes.
Where is that provision? Members of the service, anything like that?
Members of the service, check. Rule 2, check. The members of service means member of Nagaland Excise Service, recruitment to the service either before or up to the commencement of the rules. Service means the Nagaland Excise Service. And then in Rule 3 also, category of services are there. And excise constables, Lordship will find in the last. Group C, non-gazetted C, excise constables. For other services, role is more clear. But with regard to the constables, only recruitment to the service up to the commencement of the rules shall be by direct recruitment through competitive examination, stroke selection.
Where is that?
So that is Rule 5, Clause P. Clause 1P.
1A.
1A. Yes, correct.
By direct recruitment
Lordship is
through
correct.
competitive examination,
Yes,
selection.
by direct recruitment through competitive examination, stroke selection. That is the only provision for the constables. Therefore, DRP, Departmental Recruitment Board, has the authority to supplement if the rules are silent. And inclusion of written test is because of the fact that there are so many queries and then RTIs were there. So the department thought it appropriate to include written examination without causing any discrimination to anybody, which was decided more than 1.5 months in advance. It was notified and they have accepted that also.
Okay, let us go to the schedule.
Yes.
Schedule 1, Schedule 4.
Yes.
No. What is this?
Schedule 5 is syllabus for departmental qualifying examination for inspectors of excise and above.
No.
So they are not governed by that.
No, this at page 10. This says Schedule 1.
Yes.
And so many posts are there.
Yes.
Again, Schedule 2, again so many posts.
Serial number 9 is excise constables in page 10.
Yes, in 11 also it's same thing again.
Yes, same.
Why in separate pages?
Because one is under Rule 4, that is page 10, and page 11 is under Rule 5.
Then page 12 is under Rule 8.
Yes.
Pass 8, pass. Rule 8. What does a Rule 8 provide? Rule 8 provide.
For others, detail have been given in the schedule, except the constables.
specified in Schedule 3. Where is Schedule 3?
Schedule 3.
Page 12.
Yes.
Just here, it says that. Where is that?
Class 8 passed.
Qualification for.
And then on the extreme right, Lordship will find developmental selection port. Selection is changed to recruitment. Port is same, departmental is same. Only selection has been replaced by recruitment by the approval of the government. Selection is replaced by recruitment.
Department Recruitment Board.
Yes.
What was
instead
that?
of selection.
By which notification was that?
That is by annexure. Page 23. No. Page 24.
23 is exemption.
23, 24 and 25.
24 is approval.
Yes. And then the Department Recruitment Board is page 25. Because in the cabinet meeting, it was decided that instead of selection, recruitment was used to all the uniform services.
This is creation of recruitment board. It does not say in place of recruitment selection board. Correct?
Yes.
It's not replaced. It's just say that recruitment board.
Yes, Department Recruitment Board.
Qualification, it says class 8 pass.
Yes.
That's all. Then there are so many syllabus given here. This syllabus is meant for.
That is about constables, inspectors and sub-inspectors like that.
Gazetted posts. Or what?
Yes, higher posts, not gazetted, but then other posts written is prescribed. But for constables, nothing is prescribed. So in absence of the clear provisions in the rules, whether the port can supplement the rules.
What is the situation for police? In the
Police,
state?
same thing.
Is there a written exams for the police constables?
Yes.
There is.
They don't have any service rules, so in
Same thing.
this case, we have service rules which governs the selection. In the case of other police forces, they don't have any selection.
Any service rules?
Service rules, no service rules. That is why this cabinet decision was taken to govern those areas. But here in this case, we have our own selection board. Now, in contravention of this selection, these rules, especially even the port members, there are only 4 members prescribed. 4 members prescribed. Yes. Now they have added 2 more.
No, we'll come to you. Generally, we just wanted to know.
Yes.
What happens to the constable in police?
Yes.
Come to page 21.
Any exam?
My learned friend has said that police is not there. See, what are the departments?
21.
Yes.
21 of?
Writ appeal memo. The meeting was chaired by the Honorable Chief Minister and the meeting was attended by Honorable Deputy Chief Minister, Home, Honorable Minister, AFCC, Honorable Advisor, Fire Service, Home Guards, Prison, Excise, DGP means Director General of Police, ADGP, Administration and Principal Secretary, PNR, and Deliberations. The following were decided. Decisions applicable to all uniform services. So all uniform services will include police as well.
Okay.
And here, each department shall set up their respective departmental recruitment boards with representative from the administrative department, PNR, and finance and law departments. So it will cover all the uniform services. If the police personnel are not wearing uniform, that is one aspect, but they are also included in the uniform services. So it is inclusive of the police department also.
Excise is headed by? Excise Department?
Commissioner of Excise.
Commissioner of Excise.
Yes, and they are posted from the NCS cadre. Normally, a senior NCS cadre is being posted there to look after the as a Commissioner of Excise.
That is the commissionerate.
Yes.
Then at the government level,
Yes,
you'll be having,
government level.
you'll be having secretary again, commissioner,
Yes,
secretary,
correct.
excise
Exactly.
department.
They are like a director.
This is a department only.
Yes,
Directorate.
only department.
Directorate.
Yes.
So you mean to say the ample liberty has been granted to the board
Yes.
to devise the method?
Yes.
Then initially there was no test and
No written.
there was no written test,
Yes.
but about 1.5 months before the actual examination, the test was introduced.
Yes.
Everybody participated,
Yes.
including the petitioners.
Yes.
Now they cannot turn around and say that something is wrong with this.
Yes. And moreover, what legal right of the petitioners have been violated, or what statutory or constitutional rights have been violated by including written exam in the selection process. But so far as the department is concerned, in order to have a fair and transparent selection process, this was introduced. And by doing that, they have not been discriminated. Nobody has been discriminated, or it is not an arbitrary action. Equal opportunity has been afforded to all the candidates.
Without this written test, what is the test available? Only the
Physical test.
Physical test and
Physical test and oral.
interview.
Oral interview, yes.
And documents.
Yes. And as I was mentioning, the notification of 19 July 2016, which has been issued by the Commissioner of Excise, which has been relied by the petitioner as well as the learned single judge has held, is a memorandum which do not have the approval of the government. Secondly, when two examinations were conducted in 2018 and 2019, this memorandum was not followed by the department. But then by relying on this office memorandum, that examination is to be conducted in this manner, the impugned order has been passed by the learned single judge. Therefore, this judgment requires to be interfered with by the appellate court lordship. And going by the Dish Prakash Pratap's case also, paragraph 51, 52, 54, and 56, it clearly says that the terms and conditions of advertisement may also be changed in the midst of the exam, so long as it doesn't discriminate or it doesn't cause any discrimination, and so long as the action is not arbitrary, so long as it is not violative of Article 14 and 16, then that is permissible. And in condition number 15 of the advertisement, it is clearly mentioned that if there is any lapses or some discrepancy, then that the departmental recruitment board has the power to rectify that. So
that's why you put that caveat. Two provisions are there. It's like a caveat. If something is wrong, we can do it like that.
Yes.
So normally this is not done, but you have taken due care to include all these things.
Yes.
That if there's any changes, they will be rectified by way of addendums, corrigendums, and all that.
Yes, yes.
Now, what is the basic idea behind this written test? Why have you introduced written test?
There was RTI applications. Can we come to page 27?
You mean to say because of the RTI?
That is one of the reasons, and other issues are there. Let me read from paragraph 1 only.
Yes.
Detailed copy of the eligibility criteria, including educational qualifications, age limits, physical standards, and any other specific requirements for the successful selection of candidates of the seat recruitment. 2. A detailed breakdown of the marking scheme for the physical test and the suitability written test, indicating the maximum marks for each components and the minimum qualifying marks, if any. So suitability and written test is also questioned by the applicant. The prescribed ratio, if any, of male-female candidates to be recruited to the said post. Details of the constitution of the departmental recruitment board, including the names and designation of its members. Please also clarify whether any other committee or external agency is involved in any stage of the recruitment process, and if so, provide their details. 5. The specific measures undertaken by the department to prevent subjectivity and manipulation and to ensure objectivity, fairness, and transparency in the entire recruitment process, including the interview, waiver voice, etc. 6. This is very relevant. The percentage of marks allotted for the viva voice interview out of the total marks of the entire examination process. Please also confirm whether this allocation is in accordance with the guidelines laid down by the Honorable Supreme Court of India regarding the maximum permissible marks for interviews in recruitment process, the number of applications received for the said recruitment drive, the total number of vacancies advertised for the said post, details regarding the process of shortlisting candidates for the physical test, written test, and interview, including any cut-off marks applied at each stage, a copy of the advertisement notification published for this recruitment drive, the timeline or schedule for the completion of the recruitment process if finalized, the mechanism available for candidates to seek clarification or redress grievances related to the recruitment process. And then they have given 30 days time to furnish, and whatever is available we have furnished. So after receiving this, we thought it appropriate that unless the written is also included, then there will be criticisms and the award of mark only on the physical test and the oral. So in order to maintain transparency, and for that, equal opportunity was given, ample opportunity was afforded to all the candidates, Lordship. It's not that petitioners were deprived by inclusion of written test. They are not deprived in any manner. And that is the reason why they have also appeared in the written test. Out of 14 petitioners, 8 candidates have already appeared in the written. We have enclosed, there are 16 petitioners. We have enclosed in the additional affidavit who are the persons appeared also, but that may not be that relevant at this stage, Lordship.
Otherwise, the details for the requirement, how you're going to go about with the selection is given in the advertisement.
Yes.
Besides this, there's nothing else.
Yes.
Then came the corrigendum.
Yes.
Corrigendum again, where is that?
Page 29.
29 says that.
Oh, this is inclusion, yeah. 29.
But how many marks should it carry? Total 100 marks. Question pattern shall be MCD questions. MCQ, sorry. With no negative marking based on class 8 standard. Duration of the written examination 2 hours, 10 to 12.
Lordship is reading page 30.
Yes, correct.
Yes.
So there are 1, 2, 3, 4 examination centers.
Yes.
And
in paragraph 3, written examination shall carry a total of 100 marks.
What about the viva voice and the physical test? What is the distribution of marks?
That I do not have that.
That has not been disclosed in the advertisement also, no? At page 18.
Yes.
And the application form, does it contain any instruction or any something like that?
No.
Okay. 40 post. Why I'm asking you all this because RTA has asked so many questions. Because they wanted to know what is the detail, what is what are you going to do?
We have already applied.
And that is the case.
I have not seen today's publication, but I'm told by my learned friend, Mr. Takamasa, that some news items were there in even today's newspaper. About clarifying by the department how examination was conducted and why it is not declared, because they're anxious that why result is not declared and why there is so much of delay. Matter is subjudiced, so that is the reason why we have not declared this.
That is understandable. In a young population, correct. The ideal situation is to have a calendar.
Correct.
Like UPSC.
Yes.
Broad calendar.
Yes.
Yeah.
I think That is my case, Lordship, and
Now let us go to the judgment which he is referring to.
judgment.
Yes, that.
The impugned order or Dich
No, no,
Prakash?
the authority, yes, the authority.
Impugned judgment.
In judgment also you can refer to if you want.
Yes, yes. Impugned judgment, it starts from page 190. Because rest are all background. And then from page 90, again, relevant portion, I would like to start from paragraph 29, 31 to 36. These are the relevant paragraphs, Lordship, page 203.
Paragraph
29, Lordship, page 203. Because operative portion starts from here. So there are only barely about 4 pages only.
Yes.
I may be allowed to read this.
Yes.
203, paragraph 29. Upon going through the advertisement dated 7/4/2025, it is observed that it has been specifically mentioned at para 4 of the advertisement that recruitment process shall consist of a physical test and suitability test. No written test has been mentioned in the advertisement dated 7/4/2025. It is common knowledge that a candidate weighing to apply for a certain post shall prepare himself or herself according to the recruitment process, which is specified in the advertisement. If no written test is prescribed in the advertisement, the intending candidate will not prepare for the same, especially when the previous years the recruitment process for the post of excise constable did not include a written test. The respondents are expected to act in a transparent, non-discriminatory, and non-arbitrary manner while conducting the recruitment process. Good administration requires that public authority should act in a particular manner and honor to the promises made or practice established unless there is a good reason not to do so. And in all its actions, the state is bound to act fairly and in a transparent manner. This is an elementary requirement of the quarantine against arbitrary state action, which Article 14 of the Constitution adopts. In the case of Dich Prakash Pathak's, the Honorable Supreme Court stated that paragraph 23, the doctrine prescribed change of rules midway through the game or after the game has played is predicated on the rule against arbitrariness enshrined in Article 14 of the Constitution. Article 16 is only an instance of application of the concept of equality enshrined in Article 14. In other words, Article 14 is genus, while Article 16 is the species. Article 16 gives effect to the concept of equality in all matters relating to public employment. 30. In the case of Reno versus District Judge, I think I should skip this. 31. In the instant case, the petitioners as well as all intending candidates have not been given a fair opportunity of preparing for the written test, as the same was not notified in the advertisement dated 7/4/2025. That is the first initial advertisement, when the process of recruitment started. The requirement for a written test was notified only on 4/6/2025, much after the process of recruitment has begun. There is no doubt that the government has the authority to prescribe any method of selection, including a written test. However, such method has to be made known in the initial advertisement itself instead of introducing the same midway after the recruitment process has started. Hence, the corrigendum dated 4/6/2025, that is the inclusion of written, cannot stand the test of law inasmuch as the same has been issued much after the advertisement dated 7/4/2025. Additionally, as per the rules, the DRP is also not empowered to introduce such mode of selection, as it is only the government which can decide on the method of selection process. So, which provision says learned single judge has not mentioned about this? And then I was mentioning about the approval of the government under DRP, who has the power to make the changes. 205, paragraph 32. Upon going through the records, it is seen that the approval of the constitution of the DRP was obtained on 25th March 2025, which was much before the advertisement 7/4/2025. It was a policy decision of the government to include the representative of the Finance Department, Law Department in the DRP. Moreover, the petitioners have also not been able to show any prejudice caused to them by the constitution of DB. The conclusion should have been arrived on this line, because here the Law Department has also been included and PNR has also been included. Anyway, paragraph 33. As far as the physical test is concerned, the Department of Excise and Prohibition has issued a memorandum dated 19/7/2016. I have been referring to this, Lordship, by which certain physical and medical standard for selection to all post of field staff has been laid down. It is no longer res integra. The government cannot supersede statutory rules by administrative instructions. But if the rules are silent on any particular point, the government can fill up the gaps and supplement the rules and issue executive instructions not inconsistent with the rules already framed. Similarly, in the absence of any specific physical and medical standard provided in the rules of 1999 for physical tests during recruitment, the government has the authority to issue the administrative order and notifications laying down the same. This court therefore does not find any illegality in the memorandum dated 19/7/2016, and the Department of Excise is under an obligation to follow the said memorandum dated 19/7/2016 as far as physical and medical standards are concerned during recruitment of field staff. Here I have a grievance that a memorandum which do not have the approval of the government, the learned single judge has held that you should have followed this. So the nullest in the IF law, a memorandum that has been directed to be followed, which was also never followed also, and it has no government approval. So by relying on this memorandum of 19/7/2016, the impugn judgment has been arrived. Here, this is the basis where it has gone wrong.
Why does it
With
have
due
approval of the government? This memorandum does not, why it does not have the approval of the government? It does not have the approval of the government.
Yeah, it
This
do not
memorandum-
have. And if there is, let the petitioner show. But so far as government is concerned, 34.
No,
because
what is the bearing in this case, this memorandum?
memorandum
Are you saying that
prescribes.
Are you saying that this memorandum was?
Yes, Lordship, that is a pertinent question.
Uh,
By this memorandum, prescription has been given how much mark should be given and in what manner the physical test is to be
Physical, yeah.
conducted. Those things are prescribed,
That's very important.
not written. Now, let a single judge has arrived to the conclusion that, look, there is nothing wrong in this memorandum. So when it is already there, you could have strictly, scrupulously followed this memorandum.
Okay.
It is our contention that no, these do not have the approval of the government. It is only issued by the Commissioner of Taxes on his own. And by bringing this, they have constructed a writ petition, forgetting that they have appeared in the examination process. They have accepted the terms and conditions of the advertisement, and they have sit for the exam, and they are challenging by relying on this, which is nullest in the IF law, because it do not have the approval of the government. And it was never followed.
You did not follow this in the
No, never.
Then what did you follow in the recruitment?
The single judge is saying that you could have followed this notification. And it has no government approval. What is the point of following this?
No, it was the present.
And the principle which the learned single judge is saying is you should have taken the approval of the government. So, by applying that principle, this office memorandum do not have the approval of the government. So why should we apply this? Why should we rely on this? Number one. Number two, the approval of the government for constitution of the DRB is there. Government has already approved to conduct the examination. And what manner it is to be conducted, that is the DRB. That is how the terms and conditions of advertisement has been issued by the DRB on the strength of the government approval order.
Okay, so what process did you undertake?
Written exam and?
No, written exam is not there in the memorandum. But at least the standard of physical test, like supposing for female candidates, those who are pregnant, they are disqualified.
Everything has been taken care of.
This is already provided in the memorandum.
No, that is not, to not have the approval of the government, so we did not follow this.
You did not follow?
Yes.
So what did you follow then?
Physical test.
Physical test means, up to which level? Chest this much, height this much.
Yes.
From whom you will get that measurement?
They have already laid down the criteria.
Where is that? Where is that criteria?
That was not a challenge in the writ petition. So it was not necessary to bring all this.
Your Lordship may go to paragraph 20 of the petition.
Then they could have first challenge before appearing in the exam, they could have challenged that, look, law says this.
No, challenge
Which
or not.
law has been violated by the department.
Let us forget about the challenge or no challenge at the moment. Simple question is, what was the method you adopted by you?
Physical test and running, jumping, pushing.
Correct.
Push up.
What was the yardstick? Those who run within 1 minute or 2 minutes will be selected like that.
No.
Nothing. So what is the guidelines?
The port. See the constitution of the port.
Correct. The board has to be transparent. They should also speak out that this is the guidelines, at least before the court.
And the written test also. Written test was for.
No, why I'm asking is because I think this somehow you have followed these guidelines also. Because
it was not. Spirit was followed. Not specifically as per this.
Not specifically as OM, but as a memorandum, but the spirit is followed.
Yes.
Because to be in the uniform force, you have to have a particular height.
Yes.
And if you are a SC, ST, you have to have this much height. If you are from the thing, you have to have this height. So all these prescriptions are there, because otherwise, how will they say that you are selected, you're not selected?
Yes. And prepare.
Something has to be there.
People have to prepare.
If you see, for example, question paper has to be there. You have to answer the question like that. Then only the examiner will know, okay, he's good in this, he's not, his wrong answer in this question. So ultimately, analysis will be there.
Running was there, push-up was there, pull-up was there, all this.
So whoever ran, whether you finished first or last, was selected, or what?
That is by a board. It is examined by a board. And on the basis of the performance of each candidate, the board has awarded the marks.
That's what we want to know. You are representing the board also. What was the what was the criteria adopted by you? We understand that the issues regarding written test, introduction of written test, with or without, which one is correct? That is the issue. But generally, as far as the running, your marks are concerned regarding your testimonials, what did you adopt? You're saying that this memorandum is not binding.
All these documents are scrutinized by a board. It is a lengthy process to scrutinize more than 10,000 candidates. Is not that easy also. So all this has been done. And moreover, in a small state like Nagaland, or for that matter, Mizoram, the employment government service is the only opportunity for employment. We don't have any industries. Therefore, all the public are keeping in watch how exams are conducted, all this. We have to.
It is good that it should be transparent.
Yes.
It will be useful for both the person who's selecting it and those person who's participating.
So, we are concerned, it was transparent. No discrimination, no arbitrariness. Surely the exam was conducted.
Application processing should be increasingly online.
Yes.
Otherwise, manual is very difficult.
Very difficult.
Here it was manual.
Manual.
Here, yes.
10,000, not a joke.
Offline.
It should be online.
Form was
increasingly
by
online.
rupees 5,300.
Wherever possible, it's online. It should.
In future, they can adopt such methods.
Absolutely, it's possible.
Yes.
Then, in view of above discussions, observation, between corrigendum dated is quashed. Direct to conduct recruitment process strictly in terms of the advertisement. And if they decide to have a written test, fresh advertisement. What is this? State respondent shall issue a fresh advertisement complaint. Means with constitutional mandate.
Compliant.
What is this?
Mostly wrongly.
Fresh advertisement complaint. Oh, compliant. Compliant. Okay, compliant.
May I refer to the judgments?
Yes, let us go to the judgment now.
Yes. Which Prakash Patak is 2025 2 ECC.
Copy is there?
1.
With you?
We have furnished earlier, but I'm furnishing the copy.
I have one copy here.
Yes. paragraph 51,
Para 51.
52, 54, and 59. Has your lordship got it? I am taking your lordships to paragraph 51.
51.
Yes.
Yes.
May I read, Lord?
Yes.
What is clear from the above is that the object of any process of selection for entry into the public service is to ensure that a person most suitable for the post is selected. What is suitable for the one post may not be for the other. Thus, a degree of discretion is necessary to be left to the employer to devise the method procedure to select a candidate most suitable for the post, albeit subject to the overarching principles enshrined in Article 14 and 16 of the Constitution, as also the rules, statute governing services and reservation. 52. Thus, in our view, the appointing authority, recruitment authority, competent authority, in absence of rules to the contrary, can devise a procedure for selection of a candidate suitable to the post, and while doing so, it may also set benchmarks for different stages of recruitment process, including written examination and interview. However, if any such benchmark is set, the same should be stipulated before the commencement of the recruitment process. But if the extent rules or the advertisement inviting applications empower the competent authority to set benchmarks at different stages of the recruitment process, then such benchmark may be set anytime before that stage is reached, so that neither the candidate nor the evaluator, examiner, interviewer is taken by surprise. Kindly come to paragraph 54. Rules does not apply with equal strictness to steps for selection. As already noticed in section A, a recruitment process inter alia comprises of various steps like inviting applications, scrutiny of applications, rejection of defective applications, or elimination of eligible candidates, conducting examination, calling for interview or giveaways, and preparation of list of successful candidates for appointment. Subject to the rule against arbitrariness, how tests or giveaways are to be conducted, what questions are to be put, in what manner evaluation is to be done, whether a shortlisting exercise is needed, are all matters of procedure, which in absence of rule to the contrary, this is very important, in absence of rules to the contrary, may be devised by the competent authority. That is very important, Lordship. Often, advertisements inviting applications are open-ended in terms of these steps and leave it to the discretion of the competent authority to adopt such steps as may be considered necessary. In the circumstances, albeit subject to the overarching principles of rule against arbitrariness enshrined in Article 14 of the Constitution. And then kindly come to paragraph 59. Another example is in respect of fixing different cutoffs for different subjects having regard to the relative importance of the subjects and their degree of relevance. These instances make it clear that this court has been leniently in letting recruitment bodies devise an appropriate procedure for successfully concluding the recruitment process, provided the procedure adopted has been transparent, non-discriminatory, non-arbitrary, and having a rational nexus to the object sought to be achieved. So these are the principles which has been laid down in this Prakash Phatak's case, Lordship. In absence of any specific provisions in the rule, the competent authority has the discretion for supplementation, addition, so long as it doesn't affect Article 14 and 16 of the Constitution. And so long as it is non-discriminatory, non-arbitrary, then
at what stage
changes can be done. At any stage of the selection, because Lordships are well aware, selection process starts with the advertisement until the appointments are met. These are all the process of selection.
But then the concept of changing the rules of the game will come.
Yes. Changing the rules of the game after commencement of the
I
match.
thought you were going to address us that this has not caused any prejudice or any arbitrariness on anyone.
Yes.
Because this has been generally applied to everybody.
Yes, yes. No discrimination. So rules can be changed. If there is no discrimination, no arbitrary, if it doesn't hit Article 14 and 16, the rules of the game can be changed so as to supplement. But that cannot be done contrary to the provisions of the rules in violation of the service law. That cannot be done. But here, nothing of that sort is established by the petitioner. What legal right have been violated? They have participated in the selection process and they are turning around and questioning the selection process now, which the law is very clear that that cannot be done. So in the first place, the writ petition ought to have been dismissed on that ground itself. And on that point, I am referring to one judgment. There are many, but in the latest one, 2023, 17 SCC 147, paragraph 38 to 40. Let me not read that also, since it is a well-settled principle of law. Paragraph 38, 39, and 40.
$38 means it's subdivided into 38.1, 38.2.
All are relevant, Lordship. 38.38, 38.1, 38.2, and 38.3.
This is a scope of judicial review.
Others are mostly reproduction of the earlier judgments.
In short, what is the ratio laid down here? In this judgment that we've seen?
After participation in the selection process, one is part to question. They cannot turn around and question the selection process. If they are equipped, then they could have challenged the advertisement itself before sitting for exam. That this is not in accordance with law. And in the writ petition, the prayer made by in the writ petition is direct the respondents to conduct the examination in accordance with law. So we have conducted the examination in accordance with law. And if at all there is any violation of any statutory provisions, let the respondents say that, where we have gone wrong. I conclude with that.
That's all.
Lordship. I thought I will take shorter than this time. Anyway.
Lordship, with regard to the submission that we appeared without any protest, your Lordship may go to page 157. This is our representation before the interview started.
What was the first stage? First stage?
Yes.
First stage was filling application form, submitting.
Yes, yes.
Then
after that, the after
physical test.
Physical test and the oral test. That is as per the advertisement.
Then interview.
Now what happened?
Interview was last.
Interview or medical test also is there for those who clear the physical test.
Okay.
Then after that, the medical test they will have to undergo. Then after that, the Viva was to be conducted.
And written test happened when?
Written test was subsequently introduced. This is our grievance.
After Viva?
Not before the physical or Viva, but after the advertisement came out, after about 2-3 months, they brought out this corrigendum saying that we are going to introduce the written interview.
No, that we have understood.
Yes.
Only thing I was just trying to inquire is that
Yes.
what was the stages like? You say that we had submitted representation.
Yes.
At what stage?
Prior to the starting of the interview itself. Because we were aggrieved by the corrigendum, and then we were suspecting that they may not apply the provisions of the.
No, interview was the last, isn't it?
Yes. So this representation was given prior to actual commencement of the test.
What is the date of your representation?
The advertisement is dated,
It's 9th July 2025.
Your representation?
Yes, this representation.
9th July.
9th July. Here we have laid down everything, Your Lordship. You have to follow the service rules. The service rules clearly lays down the provisions that you must not change the
page
157, Your Lordship. Page 157 of the, yes, 157. If I may read. It's a 2-page representation.
May I ask one thing? What was the time gap between the notification regarding holding up a written test?
Yes.
And the actual examination? In other words, after the insertion of the new criteria,
Yes.
how much time the persons got? Just that
Your Lordship, what happened was.
may not be possible for memory.
Yes,
but,
yes. What happened was,
Course of the argument.
after we submitted this representation, they started the physical test. When the physical test was conducted, it was conducted after diluting, not as per the memorandum, existing memorandum. So we immediately approached this honorable court. Within a few days of the physical test, because the physical test went on for several days. So for those of us who about 15 of the petitioners, they appeared on the first day. On the first day of the physical.
When was that
So,
physical test?
Physical test was.
Do you know the date?
Yes. I have clearly. Your Lordship may go to page 57. This is my the statement which I have made in the.
Just give us the date.
The physical test began on 14/7/2025.
14/7.
Yes. And it went up till 24/7/2025.
24/7.
Yes. Then all the petitioners except the petitioner number 4 appeared on 24/7. No, it is 14/7. The 14/7/2025 appeared at the test. Expecting that a physical test would be conducted in terms of the memorandum dated 19/7/2026. But to their surprise, the tests applied were lower than those prescribed by the memorandum. Only 3 tests were applied, that is running 800 meters, long jump, and pull-up. Only those 3 tests were applied. Whereas, as per the memorandum, it is more stringent. Since this is a constabulary post. So when this thing happened, we were compelled to approach this honorable court by way of the writ petition. And since there was no stay order, no interim order in the matter, and the other examinations, the written examination also continued, so we were compelled to just appear. But we have clearly made representation prior to the start of the tests, which is at annexure N.
9 July.
And yes, and we have clearly in the prayer also we have made it clear, very clear. Under the facts and circumstances, we respectfully pray your authority to judiciously consider a matter and be pleased to conduct a selection process strictly in accordance with the settled practice of recruitment based on the Nagaland Excise Service Rules 1999 and eligibility criteria laid down in the memorandum dated 19/7/2016, laying down clear marking system for physical test and interview, and in the interest of justice. Needless to reiterate that in the event the selection is conducted contrary to law, we shall retain the right to seek justice in the appropriate legal forum. We trust that your esteemed authority will uphold the principles of fairness, legality, and equal opportunity in addressing this.
So nothing was done, then you participated.
So what happened
You
was,
submitted representation. It was not considered,
and then,
so you participated.
no, we submitted this representation saying that if you don't go by the rules, once we start, then in that case, we retain the right to approach the court. What happened was, after this, the physical test was conducted. We thought they would go by the law. So we went and appeared. It was not as per the memorandum, the physical test. So immediately realizing that it is not, they are not going to comply, we approached this honorable court. But one of us had yet to appear the interview, not a physical test, but the rest appeared on the same day. They experienced on that day that the memorandum is not being applied.
So everyone appeared. Everyone appeared except for one.
Appeared, yes, except one.
Who's that one?
That petitioner number 4. The petitioner number 4 was to appear on 24/7/2024-25. Because dates were allotted to all the candidates. So she had been given allotted on 24/7/2025.
Physical verification, is it?
This is a physical test.
Physical test.
Physical test, yes. Like long jump, high jump, 100 meters, shot put, and all these are prescribed under the memorandum.
Okay.
But only 3 tests were applied, which we have clearly laid down here. So they diluted the entire thing and then continued. So because of this, we approached this honorable court.
16 petitioners.
Yes.
All appeared for the test except for petition number 4.
Yes.
Then
And
subsequent.
in the meantime, there was no interim order, though we had prayed for an interim. This court deemed it not appropriate to stop the proceedings, so the court refused to pass any interim. So the test continued, all the tests, and then even the written test was conducted. So we appeared, yes. Those of us who were called, we appeared, the interview. But that does not mean that we have not protested. We have clearly made protests. And even the Supreme Court has in the judgment clearly said that taking a chance without any protest, that is a different issue. But here in this case, when protest has been made and we appeared, the state respondents coming forward saying that they took a calculated risk without any protest does not arise. That is one thing. And now, Your Lordship, service rules is very clear with regard to recruitment also, Your Lordship. Rule 5(2) clearly says that the government may take a decision, not the board.
Mr. Tompo, tell us, in what way are you prejudiced?
Your Lordship.
See, this test is not specifically meant for you. It is meant for everybody.
It is meant for everybody,
Then
but what
in
happens?
what way are you prejudiced?
What happens is, Your Lordship, they have when the physical test is very important. There, those who should qualify should be allowed to appear, Your Lordship. But the physical test, watering down the physical test, yes, if we cannot qualify, that is a different issue. But the physical test is most important. This is for constabulary. Actually, the service rules also makes it very clear that it should be between the people who are eligible should be between 18 to 25 years only. But what happened was, owing to the COVID and all these things, the government has raised the age to 35-6. Now, here in this case, educational qualification is class 8. Educational qualification. Now, because of the relaxation, even doctorates, those who have doctorate degrees, master's degrees, all have become eligible.
Class 8 to doctorate.
Oh, yes. Class 8 to doctorate.
Two,
So now, Your Lordship, and it is a constabulary course. Physical is most important, Your Lordship. Now, we who don't have that kind of qualification, That is one issue. Now,
See,
secondly, Your Lordship,
Mr.
yes,
Tompo, we are concerned with what was before the learned single judge. We cannot widen the scope.
Your Lordship, that is
All
why,
these
yes.
other additional grounds, you see,
Yes,
we cannot-
I am not, I have not raised any additional,
Yeah.
these are the grounds on which I have approached this honorable court, even the single bench. I am saying that as per recruitment rules, if the existing status quo, that means the process is to be changed, the government has to take a stand, not the board. That is one ground. And rule 5(2) also clearly says that if any changes are to be made, it is the government which must, in consultation with the government, take a decision. Only after that, change can be effective. Now, in all past interviews, in all past elections, only oral and physical and viva was conducted. Physical and then the medical and viva was conducted and selection was done in all earlier occasions.
What about the memorandum?
Memorandum, I am of the opinion that it was applied. They are saying that it is not, it has not been applied. We don't know. We are appearing for the first time. But the memorandum is there. It is being applied. That is our understanding.
Memorandum
Now,
of 2016.
yes, 2016. So starting from 2016, that memorandum was being applied. And with regard to introducing the written examination, when the service rules clearly does not provide for any syllabus, with regard to all other promotions and all other aspects, syllabus is being prescribed. At least the syllabus should be prescribed prior to the selection process starting. In this case, in the middle of the process, they have introduced. Then later on, they make another declaration that it will be class 8 standard. This kind of changing the rules, that is changing the rules. Yes, what is permissible is, for example, in the procedure, when everything has been prescribed, marking system can be changed. Some changes can be made so long as it is fair, reasonable. Those kind of steps, but everything should be laid down prior to the selection process starting. That is my case here, in this case. So the service rules has been violated. The standing office memorandum, which was brought out by the executive, because this is executive instruction, which is not contrary to the service rules. It was violated. And all these decisions the subsequent decisions were taken by the board itself. The selection board is only to, the duty of the selection board is only to conduct and review as per the service rules and as per the advertisement. They cannot make arbitrary decisions along the way. The corrigendum itself is very clear, Your Lordship will see. It is the board deciding. Now the learned senior counsel is saying that in this case, even without government approval, without the government issuing any directive, the board can do whatever they want. But whereas in the case of application of existing rules, the board can ignore that. That is their stand. That does not show transparency, Your Lordship. Something amiss is going on, Your Lordship. Because of that, and the law is there in order to ensure that everything is done as per the prescribed procedure and the law rules laid down, it has to be followed. My guess is that when law prescribes certain things to be done in a certain manner, the Supreme Court has clearly laid down. The citations I have also cited in the whatever citations I submitted, it has been reflected in the judgment of in the impugned judgment also, Your Lordship. If necessary, I'll once again I'll submit one more, Your Lordship. This is the one.
Which judgment is that?
This is 2011 10 SCC 714.
You have the book?
This is with regard to when statutory provisions provides.
This is on land acquisition.
No, this is with regard, I am only with regard to the legal principle regarding statutory provisions. Because here we are governed by the 1999 service rules. All this selection has to be done as per the 1999 service rules. And Rule 5(2) clearly says that if any changes are to be made, it has to be the government in consultation with the commission. Rule 5(2), if your lordship may.
Which para are you indicating? This judgment?
Rule 5(2) doesn't say anything.
Rule 5(2), notwithstanding anything contained in sub-rule 1. That means sub-rule 1 is by direct recruitment through competitive examination selection. A general thing is that if any changes are to be made, then in that case, the government may, in consultation with the commission, adopt such methods of recruitment to the service other than those specified in the said sub-rule. It is the government which retains the power.
So.
Not the board. The board cannot do that.
No, the government has approved the constitution of board.
Yes, constitution of the board is there.
The
but
19924 is the, it has been exempted from the NSSB.
Yes, and then the board, even the appointment of the board is, your lordship will see here, that there are only four of members under rule 7(1). Rule 7(1).
No, before that, you're speaking about.
Yes.
Rule 5. Rule 5?
Rule 5(1) says that if selection process, which is in place, any changes are to be made, then the government.
Read Rule 5(1), where does it say like that?
Rule 5(1) says recruitment to the service after commencement of these rules shall be by any or all the following methods. A, by direct recruitment, that is here in this case, it is direct recruitment through competitive examination selection. Competitive examination selection. B, by promotion of members of the service having put in minimum years of service as prescribed in Schedule 4. Now, 2, notwithstanding anything contained in sub-rule 1, if in the opinion of the government, the exigence of the service so requires, the government may, in consultation with the commission, adopt such methods of recruitment to the service other than those specified in the said sub-rules.
Something other than competitive selection or promotion.
Yes, for example,
due to exigencies of service. That
what is here, what my case is that service rules does not provide for any syllabus for written examination, and the process of selection all along had been the physical test, medical, and viva. That was the method which was adopted by the department under the rules, because the rules, when it comes to other selections, syllabus is provided. The service rules does not provide any syllabus for the constables. That means this does not intend a written examination in case of the constables.
Cannot say that. Can we say that?
Your lordship, that is right. Yes, it is silent. So if a decision has to be done.
Competitive examination / selection.
Yes, if at all it is intended, then the government has to make a decision that this syllabus should be said, this kind of syllabus should be there, and then written examination.
This is for exigency of service.
Yes.
There's no question of exigency of service.
The syllabus here, sorry.
The normal recruitment thing, there's no such kind of exigency of service.
So, but
this provides.
Yes.
No.
Criteria other than this.
Yes.
Competitive examinations, public selection.
Yes.
Let's say something.
Yes,
during
Your
the
Lordship.
COVID, some exigency to.
Government must decide. That is my stand.
Walk-in,
Not the
walk-in interview, suppose.
Yes.
Exigencies of.
Whatever it is,
In
but
case of exigency of service.
yes, if
So was there any exigency of service in this case?
yes, but it is the government. My stand is
You were right, but
Yes.
was there any exigency of service? This is a normal recruitment. And
No.
under some exceptional circumstances, you have to deviate, then government will come in.
earlier what happened was written examination was not there. In all earlier,
Maybe.
no written examination. So what happens is, even as per the Tej Prakash, the court says that unless the service rules clearly provide and the advertisement itself clearly specifies, you cannot introduce new things along the way. Even the Tej Prakash changing rule of the game is this. Here in this case, written examination was not advertised. They introduced it in the middle of the process. That is the position.
Middle of the process, but before the interview.
Yes, but the process starts with advertisement. As per that.
Process starts with advertisement.
Process starts with
Ends with the
advertisement.
recommendation.
Yes, and the court also makes it
That
very
is there.
clear, yes.
But then
So-
again, you have to segregate which process is important. Process is process, we know, A to
Yes.
Z. In between, but again, what do you mean by exactly process? And at one point of time, will there be arbitrariness or, like changing the rules of the game? There also has to again to
Yes,
be
in
examined.
in some cases, which has been discussed in the Tej Prakash Manjushri's case also, it is there, Your Lordship.
Manjushri has been.
Yes, no, for example, applying some marking systems. These are things which can be done, but introducing a wholly new concept into the system, that is a different issue.
Okay, settle.
Here, yes, here it is introducing a new thing which was not advertised.
JK Housing Board, which one you are relying on?
Here I am relying on paragraph with regard to statutory provisions.
From the government's point of view, if I'm not wrong, from the government's point of view, instead of all these, it had a very easy option. Instead of on the date of the notice, the corrigendum, it could have issued a new advertisement.
Yes.
That would not have, led to all this.
That makes sense.
Yes.
Because that you always have.
Yes.
The only says that you cannot change the rules in between, but it doesn't say that you want to incorporate something. It can always be in the form of a new advertisement.
Paragraph 32, Your Lordship. It is with regard to statutory provisions providing certain things to be done in a certain manner, it has to be done in that manner. Paragraph 32. Page 725. This is 2011 then SCC 714. In other words, even the port, not only with regard to the Rule 5(2), even with regard to the selection board, it has to be as per the service rules. It cannot, the constitution must be as per the service rules only. Even the cabinet decision is an administrative instruction. It cannot supplant the service rules.
Yes.
And with regard to your lordship, that is one aspect. Jesus. Yes, with regard to us appearing the interview with protest, the Supreme Court has consistently held that if it is without protest, yes, taking a calculated chance, it is, they cannot subsequently challenge the process. But here we have submitted we have appeared under protest. So I am just submitting a decision that is 1995 3 SCC 486, paragraph 9.
1995?
1995 3 SCC 486. Modern law.
Paragraph?
Paragraph 9, Your Worship. If I may read. Before dealing with this contention, we must keep in view the salient fact that the petitioners as well as the contesting successful candidates, being respondents concerned herein, were all found eligible in the light of marks obtained in the written test. To be eligible to be called for oral interview up to this stage, there is no dispute within the parties. The petitioners also appeared at the oral interview conducted by the members concerned of the commission, who interviewed the petitioners as well as the contesting respondents concerned. Thus, the petitioners took a chance to get themselves selected at the said oral interview, only because they did not find themselves to have emerged successful as a result of their combined performance, both at written test and oral interview. They have filed this petition. It is now well settled that if a candidate takes a calculated chance and appears at the interview, then only because the result of the interview is not palatable to him, he cannot turn around and subsequently contend that the process of interview was unfair or the selection committee was not properly constituted. In the case of Om Prakash Shukla versus Akhilesh Kumar Shukla, it has been clearly laid down by a bench of 3 learned judges of this court that when the petitioner appeared at the examination without protest, and when he found that he would not succeed in examination, he filed a petition challenging the said examination. The High Court should not have granted any relief to such a petitioner. So here our exception is that we appeared after protest, under protest. So the ground raised by the Learned Senior Council does not apply in our case. Now the other one. Yes, 2011-12 SCC, Your Lordship. This is what regard to
Page?
page 85.
Paragraph?
11-12 SCC, page 85. This is what regard to again
Paragraph?
selection, paragraph 29, Your Lordship.
Regarding?
Regarding the selection process when the law clearly lays down. It is a different side of the coin with regard to this, Prakash.
But how does it apply to your case?
Here in this case, what it says is that if a particular advertisement is there, it has to go by the advertisement itself. That is the crux I want to point out. It has to go as per the advertisement.
That is what is given in para 29.
Your Lordship, consequently, when a particular schedule is mentioned in an advertisement, the same has to be scrupulously maintained. There cannot be any relaxation in the terms and conditions of the advertisements unless such a power is specifically reserved. So it's a general principle that where advertisement says something clearly lays down certain things to be done, it has to be scrupulously applied. And even if power of relaxation is provided in the rules, it must still be mentioned in the advertisement. In the absence of such power in the rules, it could still be provided in the advertisement. So advertisement is very important, Your Lordship. Not a subsequent corrigendum.
To put it alternatively, the question before us, looking at it from another perspective, is that within the constitutional mandate and Article 14 and the laws we have been laid down, to what extent a corrigendum can modify an advertisement?
Yes.
So as to be valid. So one example has been given in this judgment, this Prakash, one of the discussed judgments. Within the judgment, that interview was there, and after the interview was held, they introduced a minimum cutoff mark for the interview.
Yes.
Because of that, the person could not get selected.
Yes.
So that was held to be
not
good. That was held to be arbitrary.
Yes, but what they are, as per this, the paragraphs which the learned senior counsel provided. Paragraph 32, na? Was it 32? Page 51, 50, 56, and 59. 51, 52,
So in that context, whether introduction of a written examination would satisfy that test. That is the thing.
As per this, paragraph 52, in our view, the appointing authority, recruiting authority, competent authority, in absence of rules to the contrary, can devise a procedure for selection of a candidate suitable to the post, and while doing so, it may also set benchmarks. These benchmarks are a different issue. For example, these tests are to be applied. These tests are to be applied. All these are advertised. To qualify this benchmark is set. To qualify this benchmark is set. That is, those are permissible. Those are the benchmarks, which this paragraph 52 is talking about, Your Lordship. Not introducing something which is new, because this judgment itself has made it very clear in this text, Prakash, in the other paragraphs which I have also referred before the learned single bench. You cannot introduce new things along the way.
You can, as per the text, Prakash, you can subject this, provided it is permissible by the rules.
Yes.
Or the advertisement.
Yes.
Which is in conformity with the rules.
Yes.
The advertisement allows.
Yes.
And the advertisement is in conformity, that allowing is in conformity with the rules.
Yes.
Or the rules itself allow.
Yes. So the rules does not allow.
Suppose the rules allow. Suppose the rules say that after the interview is held, you can set a minimum mark. Then this example is passed.
Yes, that is permissible. But here in this case, the rule does not give that power. And even the advertisement does not. So in that instance, they could not have introduced a written examination.
And that is why also, sir, I asked you that question. that, that how much time was the candidates got about between, because one argument you said that, okay, this is the syllabus I prepare like that. Suppose you introduce a new syllabus.
Yes.
Obviously, it will, it affects to all the candidates.
Yes.
Right.
They kept on issuing.
They got how much? 1 month?
Now and then, 1 month, around 1 month. They kept on issuing courage and
They kept on issuing means how many?
They kept on changing along the way. This is the problem, Your Lordship.
How many corrigendums were issued?
Ideally, for any public recruitment, written examination is always better.
You're saying they kept on issuing.
Yes. Well, it's always, risky.
Yeah.
But the problem arose here because it came in between.
But even in this stage, Prakash, the court has also held that written exam, the difference between written exam and the viva is that viva objective. It can, through the interaction, an objective impression and can be arrived at. Whereas if it is written, it is subjective in nature. So having the viva,
No, it's
only
other
having
way
the
around.
viva itself, Your Lordship, and this is with regard to constables. The presence of mind is very important.
Where is
And
that?
even physical.
Where is that introduction of the written test? Just let us see the page 29, I think. 29.
Yes.
Then at page 30. MCQ,
Yes.
no negative marking.
No. The original is 29.
MCQ means what? There'll be 4 choices.
4 choices.
A, B, C, D. You have to just to take A, B, C, D, which one ever.
Multiple choice question.
So this is the written
This is
examination.
Third shown.
Subjective type of class 8 standard,
Yes.
2 hours timing.
Yes.
You are prepared for interview.
Yes.
How difficult it should be to sit for this
Like
MCQ
we have
exam.
said, it is, if they had prescribed the syllabus, a general class 8 standard does not mean it is not specific. It's a general class 8.
In the present
How
times,
many you say
increasing.
that this is class 8, this is class 9, this is
Yeah.
class 10. It's a very general
In the
kind of,
present times, increasingly, it has to be
Yes.
specified also.
it has to be specific.
But that may not be
Yes.
fatal in a particular case. Here we are on a different, confronting a different issue. The introduction subsequently is the issue. Anyway,
They have kept on changing the goalposts along the way, and this is that I don't. My humble submission is that the permissibility laid down under Prakash, if Prakash does not give that kind of leverage to the state respondents, it's very narrow and very limited. That is my humble submission, Your Lord.
Okay. That's all?
Yes, Your Lord.
Any reply? Mr. Jamil?
In view of time constraint, Lordship, I don't wish to reply much, but only on one point, Lordship. Whatever submissions my learned friend has made, these are all taken care of by this Prakash case. That is one. Secondly, the Lordship was putting a query on to my learned friend on the memorandum of 19/7/2016. The single judge held that you conduct the exam in accordance with this 19/7/2016. And this honorable court, it is just a hypothetical question, but then I believe it makes sense. This honorable court dismissed the writ appeal. So the direction of the learned single judge will have to be followed. By conducting a fresh recruitment process basing on the memorandum of 19/7/2016, in which case examination will go on tomorrow. A group of persons will come and say that, look, this memorandum do not have the government approval. And you are conducting the examination on the basis of this office memorandum and then challenge. What kind of a decision and how this honorable court can decide in such a situation? That is one. On that point, on the same point that OM memorandum of 19/7/2016, my learned friend was arguing on other side that if there is any changes to be made, that can be possible and done only with the approval of the government, and that can be done only by the government. That was his submission. Accepting that submission. Now, if we are to go as per his submission, that it is only the government who can make the changes, and only under approval of the government it can be done. Then, memorandum of 19/7/2016 do not have the approval of the government. So, by making such a submission, he is blowing hot and cold, which cannot be accepted also. And so far as the approval of the government is concerned, what more approval of the government will be required more than the page 24, 25th March 2025, by which DRP was allowed to conduct the examination. And basing on the approval of the government, they have done. And what other approval will be required more than that?
Okay.
So there is government approval so far as this examination is concerned. So with that, may I conclude, Lordship? I'm highly obliged for the patient hearing. Whatever we wanted to put, we have put. We were allowed to put, Lordships. So now the ball is towards honorable court.
Okay, please write. Mr. C.T. Jamil and his senior counsel, assisted by
Aliba Ozakum.
Mr. Aliba Ozakum for the appellants, and Mr. Tongpok Pogana, learned counsel for the respondents. All respondents.
All the private, all the respondents, yes. Respondents, petitioners.
Hearing concluded, judgment reserved. The books will be required, huh? I can print also. That's why you need to get I think, board tomorrow. That board that you have. Because this thing is too small. So I prefer having a board. Board. Not bad, board. Clipboard.
Clipboard.
Okay. This is one more thought.
Yes, I took a chance. Maybe, my lords, my lord, it might not be possible today. We took a chance.
Paper book is ready.
There is a difficulty with this.
Yeah, it fits. But he's in jail, I guess.
Yes, lordship. He's in jail.
What's the sentence?
Conviction under?
10 years.
Conviction under?
Lordship.
Conviction under which section?
Conviction under 376, lordship. And 06, yes, rape.
376. And what is the sentence?
Sentence is 14 years, lordship.
14 years. He's in jail.
Yes, he is in jail.
No bail, isn't it? And conviction by which judgment? Dated 2023.
2023, lordship, yes, correct.
So PP is not there today. PP is left.
I think he has left, lordship.
Okay, when do you want it?
Lordship, it will be only as and when there is an available bench, because next week it cannot be taken up because Justice Wailong Kumar was the presiding judge in doing the proceedings, one of the proceedings.
Oh, I see.
So there's a difficulty in listing the matter in itself. So that's why I took a chance today, lordship.
Yeah.
So then on the opening then. Please write, due to paucity of time, the matter could not be taken up for hearing today. As paid for is the matter for hearing after the ensuing summer vacation.
Yes.
On a date to be fixed by the registry.
Just one more thing, Lordship. In this matter, the respondent number 2 is not yet represented. So if that would be a
Notice can be issued.
notice, yes.
Yep.
It has been issued, but then
But this is not a POXO matter, isn't it?
this is not a POXO matter.
Essential.
No.
Notice has been served.
Served, Lordship.
Then
No
amicus
time
can be
back.
appointed.
Yes, that can be done, Lordship. And amicus can be appointed.
So do you have a list of amicus?
No.
You don't have a list, you should have a list. Because we don't know the names, no?
Yeah, legal aid. Legal aid.
Legal aid
Services.
councils.
Legal aid council.
Please write, it is also noticed that despite no service of notice, since no one has appeared for respondent number 2, we deem it appropriate to appoint so and so as the legal aid counsel or amicus, as the amicus to assist the court and appear for respondent number 2. Stop, registry shall furnish a copy of the paper book to the appointed amicus curiae within a week. Just give us that list and we'll incorporate the name. Okay? If there's any list, otherwise, any suggestion from your side, any name?
Lordship, the registry can endorse. I'm also a legal aid counsel, but then
But there's a list,
there's a list, Lordship.
so you get the list. Get the list, huh? Ask for the list and you send it. We'll just incorporate that. Okay. Any more?
No more.
Okay.
Much obliged, Lordship.
So,